doing well today.
Good morning, Your Honor.
Morning, Judge.
Good morning, everyone.
Morning.
Good morning, Judge Morrow.
Good morning. Give us just a moment here. We'll have Ms. Lewis in court with me today, and we're having some computer issues, so just give us a moment.
Okay, not a problem.
All right, who do we have first?
Gonna be position 36, Mr. Terriot. Oh, let me make sure. You know what? No, disregard. Miss Helen is not in yet, so we're gonna wait off on you, okay?
Okay,
Mr. 2, Mr. Binion here.
Yeah. We're gonna start with position 2, Mr. Binion.
and this is a negotiated plea.
It is.
Good morning, Mr. McLean. I hope you're well.
Good morning, yes, hope you are.
Good morning, Mr. Binion. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear to affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Binion. Morning, Mr. Walker.
Good morning, Your Honor. The state's recommendation is 12 months to serve, 20 days, credit for time served, 10 days, balance probated with the conditions of a SDET course, and a stay away from all Walmarts in Fulton County.
All right, Mr. McLean.
Right, he would like to accept that a negotiated plea and ask the court to accept his plea. I would point out, Your Honor, he is indigent, and these SDETs, the kind that's just a plain SDE evaluation, does run about $1,500, and he is homeless and indigent. So he'll do his best to get out there and scrape up the money or find an alternate source. But through the last several years, I really haven't seen any alternate source of that kind of evaluation.
Okay. Mr. Binion, it's my understanding that in case 22 CR 007934G, you wish to plead guilty to one misdemeanor offense. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury.
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Binion. I am going to waive your probation fees for you while you're on probation and help you get and stay on your feet. But you're going to have to be on probation for the entire time, okay?
Yes, sir.
All right, good luck to you, Mr. Binion.
Yes, sir. Thank you.
Position 15, Hampton.
This is going to be an arraignment and a bond hearing.
Let's see, I believe that is correct. Yes.
Yes, good morning, Mr. Hampton. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, I do.
Thank you. Can you raise your right hand for me, sir? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, correct.
All right, you can put your hand down. Thank you. Mr. Hampton, you've been charged in case 22 CR 007936C with stalking. This charge carries a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. McLean?
Yes, Your Honor. He has a copy, or I have a copy, and we've looked at it.
How do you plead, Mr. Hampton? Guilty or not guilty?
Not guilty.
We'll record your not guilty plea. Your case will be returned to the division judge and you'll receive notification of your next hearing date. Do we have his bond?
It's a $1,500 surety bond, Your Honor.
Okay.
If there's any way he could get a break further on the bond, that would help him make it. He is young and he doesn't have a job right now. And when I talked to him, Your Honor, last evening in the jail here, he really does understand the stay away. He is, I think, I'll just put it this way, I think he gets it.
And Your Honor, the state's position is that there has been no change in circumstance. We are very concerned about him contacting the victim. Just to give you a little information about this case, he's called several welfare checks or called the police for welfare checks for the victim numerous times. Her name is Charlita Bunton. After the officers come to her home, she's explained the situation. After the welfare checks, he showed up to her home each time, at least 4 different times, I believe. The victim is very concerned about her safety. She made it clear with the defendant that she does not want any contact, and he continues to call the police to do welfare checks. And then when that doesn't work, he makes contact by coming to her home. So he obviously knows where she lives. And the victim, this young lady, is very concerned for her safety, as she should be. A $1,500 surety bond is more than reasonable, and we ask that it stay in place.
And I think the state would agree with me, though. Isn't this the first time he's been arrested on that?
It might, I believe it is, but nonetheless, he's went to great extent to continue to make contact, and not only make contact, but call the police for welfare checks multiple times and came to our home multiple times. So a $1,500 surety bond is more than reasonable.
And Your Honor, I would, excuse me, Naomi Campbell on behalf of the state, I'd like to add that the victim actually filed 3 prior police reports. So when the police arrived at her home, the victim did show the police that she had filed 3 prior reports against this defendant. So whether charges were actually filed or not, the state doesn't know, but she did call the police 3 times. And this was the 4th incident, as ASG Walker stated. And I did have an opportunity to listen to the 911 call that this defendant actually made for the welfare check. And the statements that he made in the 911 call were very concerning, and they were lies. He claimed that the victim's father was doing voodoo on her. And so he was scared that the victim's father was going to rape her and do voodoo on her. So that's why he wanted the police to go out and do a welfare check. And when the police arrived and spoke to the victim stated that none of that was true, and that she had had no contact with this defendant for a long time. In fact, she had told him over and over again to leave her alone. So the state was actually going to be asking to perhaps have his mental health evaluated, because, you know, he's making all these phone calls to the police for welfare checks, showing up at her house and, you know, claiming that her dad did voodoo on her. And that's not normal behavior, Your Honor. So the state is concerned about the victim's safety, as ASG Walker stated.
Yeah, I was simply making the point that with this being the only arrest, that this has impressed him.
So Ms. Harrison.
Good morning, Judge.
Good morning again. Is there no history at all?
No prior history.
Okay. Okay, so I think based on what I've heard, I don't see any change in circumstances. I'm gonna leave the bond where it is. Good luck to you, Mr. Hampton.
Position 26.
Okay, sir, you got to come on this side.
And this is a non-negotiated plea.
That's correct, Judge. Good morning.
Good morning, Ms. Helen.
How are you?
He's right here.
Oh, okay, great.
Okay. Can you hear me all right, Mr. Kendrick?
Yes, sir.
Good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Since this is non-negotiated, Ms. Harrison, can you give me the history, please?
"48 cycles. Last arrest was July of this year, failure to appear in Fulton County. Underlying charge was not indicated. There is, one moment. I have a 2020 criminal trespass conviction. (2018) criminal trespass conviction. 2018 possession of marijuana less than an ounce. Trespass 2017. Another 2017 trespass, willful obstruction in 2017. Additional 2016 criminal trespass. And a 2018 trespass. They're all trespass. 2016, another.
Okay, thank you. Ms. Campbell?
Yes, Your Honor. The state's offer in this matter was 12 months, serve 120 days, credit for time served 13 days, the balance to be probated, a stay away from the incident location, which is 5875 Old National Highway, as well as an anti-theft class. And as pretrial stated, this defendant has numerous prior cycles for trespass. And so that is the reason for the state's recommendation. The state believes that his recommendation is very appropriate in light of their actually being arrested all the way back to 2005 for trespass. So I wrote down that he has 2005, 2006, 2010, 2012, 3 times in 2012, 2014, 2015, 2018, and looks like another 3 to 4 times in 2017. And then it looks like there's another arrest in 2022 for trespass that's not this incident. So we have well over 10 prior arrests, and most of them are convictions for trespass. So the state does believe that its offer is very reasonable in light of this defendant's prior history. The facts for this particular incident are that on the date of September 2nd of 2021, this defendant actually stole a 6-pack of beer out of Chevron located at 5875 Old National Highway. An officer did review video footage of the theft, and he did observe at that time when he was looking at the footage, the defendant walking back towards the gas station. And at that time, he did tell the defendant that he could not enter the store. The defendant began to cuss at the officer, and he began to actually shove the officer as well. And so the defendant and the officer actually got into a physical altercation. And so 2 officers had to actually take this defendant down. So the state does believe that, like I said, the recommendation is appropriate in light of the fact that this defendant also used violence towards an officer. And I would like to note that his prior history does include at least 1 prior conviction in 2017 for obstruction and 2 prior convictions for disorderly conduct. So this is in line with the defendant's history. He seems to be non-compliant with officers, and also combative and violent towards officers. So the state is going to be recommending that 12 months to serve 120 days, Your Honor. Nothing further.
Yes, Ms. Helen.
Good morning, Judge. This is a non-negotiated plea. I went and spoke to Mr. Kendrick. The state has credit for time served 13 days. I want to update that. Mr. Kendrick has been incarcerated since August 20th of 2022. That's 109 days. I actually don't have a criminal trespass case on my calendar. The position that we're addressing is the theft by shoplifting of a beer from a Chevron. The willful obstruction, he resisted arrest. I just want to state clearly that if it was violence offered, that would be a felony obstruction. Today, he was charged with a misdemeanor obstruction for resisting arrest. So I just want to clarify that, Judge. We're asking for time served, balance suspended. He's been incarcerated 109 days. Mr. Kendrick, as you can hear from his history, is residentially challenged. I'm trying to work with him to get him into Gateway, which offers documentation, housing, showers, food. So Judge, for this case, this non-violent case, we are asking for time served, balance suspended, and we're asking for the credit of 109 days be given to this case. Again, he's been incarcerated since August 20th of 2022.
Has it been on just this charge or other charges, Ms. Helen?
I see this case, but he also has a criminal trespass on his booking screen. I only see for position 26, the theft by shoplifting and the obstruction, Judge.
Judge, this was a bind over from the city of College Park. He was shipped from College Park to here for this case. He's only in jail for a criminal trespass, which is not on the calendar.
Thank you, and that's exactly correct. And when I went and spoke to Mr. Kendrick, we were trying to figure out why it was a bind over, but he was arrested by College Park and then released the same day. So Judge, we are asking for time served, balance suspended. Again, Mr. Kendrick has been continuously incarcerated since August 20th. That's 109 days.
Where's the criminal trespass now? Is he still going to be held on the criminal trespass?
That's correct. You will meet Mr. McBride a while ago, and it's not been accused.
Okay.
And so that is correct, Judge. I was going to ask Mr. Michael Jordan if we could have that case on the calendar, because it's not here, but it is showing on a booking screen.
Hold on, Mr. Kendrick, Ms. Helen, Mr. Kendrick is trying to get your attention.
Hold on, Mr. Kendrick, okay?
So I would prefer to handle all these cases at once. Can we, especially if he's going to be held in jail on a criminal trespass that hasn't been accused. Mr. Walker, can we get that accused and get this placed back on the calendar?
Can that be done by Thursday?
Yes, Your Honor. If it's been bound over, we certainly can get it accused.
Okay. Well, I know what I'm going to do, Ms. Helen. I don't know what another judge is going to do on Thursday. So you can take your chances with me, or you can take your chances with another judge on Thursday. But, you know, depending on what the criminal trespass is, you know, you might want to see me. But it's up to you. So you want to.
We'd like to reset it for you, Judge. He's just going to do another week, but we'd like to reset it to Tuesday, add that criminal trespass to this additional case, Judge, so we can hear them together.
Okay, Mr. Kendrick, Ms. Helen's going to speak with you after court today, because you have a right to remain silent. Anything you say can be used against you, and it might not be helpful, even though you might think it will be. So speak with her after court today, and she will relay to the court anything that you want her to relay to me. Okay.
I'll be coming to court next Tuesday or this Tuesday. Next Tuesday.
13.
Yes, on the 13th. Okay. You have another charge that's not on this calendar, Mr. Kendrick, and I'd like to handle all those charges together so that we can.
I just got a trespass. I've been here 3 months for the criminal trespass, and I ain't been the first appearance yet. I got a lot of them each month for it.
Okay, all right, so that will be addressed. Ms. Helen, is that what you want to do?
Yes, Judge. And Mr. Kendrick, I'm here at the jail. I'll come speak to you after court.
All right.
Okay, thank you. I'll see you next week, Mr. Kendrick.
Mr. Shannon Jackson, he's a probation revocation position 1.
And good morning, Madam Interpreter. How are you today?
Good morning, sir. Having a little problem connecting. I apologize about
Okay,
the late.
you're fine,
Thank
you're fine. And who do we have on from probation? Good morning, Ms. Giddings. Is this your case?
It is my case, Your Honor, but I do not see the probation officer.
Okay,
It's JCS,
I am here.
Oh,
I'm
thank you.
probation officer, Miss Edwards. It won't be Miss Harris today. She had court at the courthouse this morning. Sorry about that.
that's fine. Good morning, Officer Edwards. And let's see. Good morning, Mr. Jackson. And where is Mr. Jackson in courtroom 2? Is that where we are?
Yes, Judge.
Okay, good morning, Mr. Jackson. This is the probation revocation calendar that we've conducted by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Officer Edwards?
All right, Your Honor, we're here today for Mr. Shannon Jackson, case number 18 CR 005-026E. The defendant pled guilty of battery, family violence on the 7th of February 2019 and was sentenced to 12 months of probation. The defendant has violated the terms of probation. He failed to report on his revocation hearing on December 18th, 2019, and the defendant failed to complete the domestic violence intervention program. Mr. Shannon Jackson has a little less under 30 days remaining on his case, Your Honor.
And what's the probation's recommendation?
What's the recommendation from probation?
And the recommendation is revoke the balance with time served.
How much time has been served?
One second, Your Honor. I was just thrown into this morning. Please bear with me.
Okay.
It's been in jail for 8 days as of today.
So I guess my question, Officer Edwards, is
Mr. Moore.
I can't understand what she's saying, Your Honor.
I think she's on the telephone with someone else.
Okay.
I'll give her a moment.
Judge, I'm just a little confused. I do have an order from Ms. Harris, the probation officer, asking please dismiss this warrant. It was filed December 1st, 2022. A record of
Okay, yeah.
policy, so I just little.
That was going to be my recommendation as well, Your Honor.
We can go along with that recommendation, Your Honor.
Thank
But
you.
we're not sure how long he's been in jail.
Okay,
I'm with you. Thank you, Ms. Harris.
I'm being told that he's been in jail for 8 days. So you all, is the recommendation from both sides to for it to be 8 days time served and that's it?
That is the solicitor's recommendation, Your Honor, to just give him credit for the 8 days and administratively close the case.
Yes, sir. Yes, ma'am. We agree.
Okay, so that's what we'll do. All right. Good luck to you, Mr. Jackson. All right. Ms. Giddings, I'm sorry you're throwing me off because you've got the ASG beside your name, and that's not how I'm used to seeing you. So
Yes, I know.
back and forth. But it's good to see you regardless.
Thank you, Your Honor. I've thrown a lot of people off this last week because they keep asking and sending me chats. Is that a mistake? Is that a mistake? And I'm like, no, it's not a mistake.
Okay. Who do we have next?
Position 23 and 24. Mr. Jackson.
And this is going to be an arraignment.
For both positions, Judge.
All right, good morning, Mr. Jackson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're handling by video. Do you agree to have your case heard by video?
No.
You don't want to dispose of your case today by video, Mr. Jackson?
Yeah.
Okay, so it's all right that we do this by video, right? Okay, can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Sure.
Okay, you can put your hand down. Mr. Jackson, you have been charged in case 22 CR 004559Y with theft by taking, and in case 22 CR 005082Y with loitering and prowling and obstruction of a law enforcement officer. Each of these charges carries a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusations, Ms. Helen?
I do, Judge.
How do you plead to these charges, Mr. Jackson? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date, okay? Good luck to you, sir. Who do we have next?
Next, we have position 13 and 14, Mr. Kyron Griffin. That's conflict, counsel, Your Honor.
Okay.
There was an email before that one of our public defenders had determined there was a conflict and a notation, I suppose, was made. So he withdrew from the case.
Okay, is this Mr. Murphy's case?
No,
No?
no,
Whose case is this?
it's not, we gotta get one assigned because we were not aware that it has a conflict. We were just not being told.
Okay. All right, so I don't want to, let's reset this for Thursday. Given the offer, I don't want to put it off longer than that. So if we can get him an attorney by Thursday, so we'll reset this until the 8th. Ms. McLeod, are you with us?
Good morning, Your Honor.
Good morning, Ms. McLeod. We need a conflict attorney for Mr. Griffin. Would you be willing to take on that case and speak with him regarding that matter?
I'm sorry, Your Honor, I didn't hear.
Can you hear me?
Yes, I can hear you now.
Okay. Did you hear what I said? No?
No, Your Honor.
All right. Mr. Griffin is in need of a conflict attorney. Is it?
So once again, give us that part. I'm sorry, Your Honor.
Can you hear me now, Ms. McLeod?
Yes, I can hear you now.
Mr. Griffin is in need of a conflict attorney. Instead of
Yes, sir.
rescheduling him for next, for Thursday, would you be willing to speak with him now to see if, to take on his case?
Yes, Your Honor.
Okay, so can we put Ms. McLeod into a breakout room with Mr. Griffin? So she can- Yes.
I'm gonna put him on the phone. So
Oh, he's here. Okay, I'm sorry. So can you, if you'll just call Ms. McLeod. Thank you, Norris.
You're welcome. And can we go to position number 10, Mr. Dulac?
Okay. This is going to be a negotiated plea.
It is.
Good morning, Mr. Dulac. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Mr. Dulac, Mr. Walker,
Yes, Your Honor, the state's recommendation is 12 months to serve, 24 days, credit for time served, 12 days, balance probated, anti-theft course, and a stay away from all Walmarts within Fulton County.
Mr. McLean?
Your Honor, in a similar fashion to an announcement I made before for another client, he does want to emphasize that he is indigent. He will do his best to go out there and do odd jobs if he needs to cut grass, rake leaves, to scrape up money to take that theft course. It's not as expensive as the other one I mentioned earlier today. But he asked the court to accept his negotiated plea.
And I do believe the theft course is only a 1-day course, so it shouldn't be overly burdensome.
Those are a couple $100 probably. I'm hoping it might not be more than 150, which is a factor of 10 to 1 on the other thing I was mentioning. But he does ask the court to accept this negotiated plea. He is residentially challenged, so it's going to be very, very important for him to stay in touch with probation, since I have no contact information.
Okay, Mr. Dulac, it's my understanding that in case 22 CR 007961E, you wish to plead guilty to theft by shoplifting, is that correct? Say it again for me, sir. Is that a yes? I'm having difficulty hearing you, Mr. Dulac. So if you can speak up for me, please.
Yes, sir.
Okay, thank you. Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and if by pleading guilty, you're giving up your right to a trial by jury? You don't want a jury trial, do you?
No, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Dulac. I'm going to waive the probation fees while you're on probation to help you get and stay on your feet. And when you complete the theft class, it's going to be probation is going to terminate. So the sooner you get that done, the sooner you don't have to be on probation. Okay.
Yes, sir.
All right. Good luck to you, Mr. Dulac.
Position 37.
Just 1 second, Your Honor, if I may provide some information to PD McLean. There is a anti-theft course for $25 that can be found at GeorgiaTheftAwarenessCourse.com.
Georgia Theft Awareness.
Yes.
Thank you so much.
You're
Thank
quite
you,
welcome.
Mr. Giddings.
Thank you.
And this is position 37, is that right?
Yes, Mr. Walker.
Okay. And this is going to be a negotiated plea.
That's correct, Judge.
Good morning, Mr. Walker. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear to affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. Ms. Giddings?
Yes, Your Honor. The state on the willful of obstruction is offering 12 months to serve 30 days, credit for time served, 21 days, valid suspended, and time served on the possession charge.
And yes, Judge, that is our understanding of that offer. We do accept that offer for Mr. Walker, and we do stipulate to the factual basis, venue, and ID.
Okay, Mr. Walker, it's my understanding that in case 22 CR 007840Y, you wish to plead guilty to willful obstruction of a law enforcement officer and possession of marijuana less than an ounce. Is that correct? Is that,
Yes.
are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes,
Is that a
sir.
yes? You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced you or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Walker. Good luck to you, sir.
Thank you, Your Honor.
Thank you. Who do we have next?
Position 3, Blessing Game.
And this is going to be an arraignment and a bond hearing.
Yes, Your Honor.
Good morning, Mr. Blessing Game. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Mr. Blessing Game, you've been charged in case 22 CR 00793 with disorderly conduct and 4 counts of simple assault. Each of these charges carries a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. McLean?
We do. We have copies.
Okay. How do you plead, Mr. Blessing Game? Guilty or not guilty?
Not guilty.
So record your not guilty plea. Your case will be returned to the division judge, and you will get notification of your next hearing date. Let's see. I have bond for the disorderly conduct of $500 good bond, and for the simple assault, a $1,500 good bond. Were the other 3 simple assaults added at a later time?
I believe it was a amended accusation, Your Honor, but there are 4 different victims in this case.
Okay, so let me just start, since there's a request for a bond modification. Let me start with Ms. Harrison and the history.
He has 2 cycles, Judge, no convictions on his GCIC.
Okay. Mr. Walker?
Yes, Your Honor. I'm sorry, my odyssey just froze, but on November 16th of this year, Mr. Blessing Game did come into the Fulton County Voter Registration Office, which is located at, I believe it is 130 Peachtree Street. Mr. Blessing Game is a poll worker. He came there on that day to inquire about his paycheck. After speaking with one of the employees of the voter registration office, she had explained to him that the paychecks were not ready, but she assured him that he would be paid. It's important to note that in this case that Mr. Blessing Game had previously came to the voter registration office for the same exact reason, and the same was explained to him on that previous day. And he made a disturbance on that day as well. But on this day, he refused to leave. He threatened the workers in the office that he was going to F them up, to the point that they had to go get Fulton County Sheriff deputies to come to address Mr. Blessing Game. He referred to the deputies as pussy ass church boys and to fuck the DA, and then he will fuck everyone up. He caused a scene. He refused to leave and threatened everyone in the office if he did not receive his paycheck. Obviously, we take the safety of our Fulton County employees very seriously. He is a threat. He came to their office more than one time. They were very sensible and reasonable, but Mr. Blessing Game came there with a violent attitude, if you will, and threatened to harm them and the deputies who responded to the incident. At that time, he was transported to Grady for an eval, and then he finally was released to Fulton County Jail. So I said that to say the state will be asking the bond remain as said.
Okay, well, you have a recommendation. You want a $1,500 good bond on each of the simple assaults charges?
Yes, Your Honor.
Okay.
And obviously stay away from the victims' names. And I do have those victims' names if you need them.
Okay. Mr. McLean?
Your Honor, at the time Bond was last visited, I believe, I may be wrong on this, correct me if I'm wrong, but I think there was a CP case on a portion of the case pending. And I think when it was all looked at by the state, they decided, let's do this as this charge. Let's take this and modify it to that charge. So this is kind of a fresh look and something that is now settled down. Certainly the temperature is down and everything. It's been several days. Everybody's completely calm about the thing. And he did want me to point out that something was not brought up at his first appearance that he felt should have been brought up, which that he was recently elected chair of the Glen Rose Heights Civic Association. So while it was stated in the previous hearing, not this hearing, that he could be a danger to the community, he would like to make the point he's certainly not a danger to the community. He's trying to be a leader in the community and has been recognized as such being selected for that position. I don't have any proof or documentation of that. That is from him and has given me some people. We can check it out and make sure it's true. And so I'm sure it is. So that's the main point, Your Honor. He needs a signature bond. Obviously, he was there because he needed his paycheck, and it's a shame that things got kind of heated, but he does need the assistance of the court to gain his freedom, and a signature bond, given his essential lack of record, would be appropriate. Obviously, the community ties are there. They wouldn't have him in the Civic Association as chair.
And I would just respond, I'm not familiar with that position. I'm not sure if it's relevant to the Ayala factors, but at the end of the day, he came to a Fulton County government office twice in 1 month, and both times he caused a disturbance to the point where 4 different individuals felt threatened and they had to call Fulton County deputies to come, and he threatened to F all of them up. So just think that it's important for the court to know the seriousness of the facts of this case and the victims involved.
If you'll put the state's offer on the record, Mr. Walker.
In 1 second. So the states, and this is the case that we had to send a follow-up email. The state's recommendation is 5 months. I'm sorry, 5 years to serve 90 days. Credit for any time that he has served, balance probated, a mental health evaluation, anger management, and for any and all firearms to be seized. And that I did say that correctly, 5 years to serve 90 days. So it's a 12-month sentence to run consecutive to each count.
All right, so that's different than what I have on.
That is correct. And I sent 2 emails yesterday. I believe that you were CC'd on those emails with the state's updated offer, and that the state was rescinding its offer that was sent initially.
Okay. All right, so Mr. McLean, if you'll take this down.
Yes.
For the disorderly, I'm going to leave that at a $500 good bond. For each of the simple assaults, it's going to be a $250 good bond, which makes for a total of $1,000 good bond. So it's going to be a total of a $1,500 good bond. Stay away from the 130 Peachtree Street unless he's there on official business. And no drugs, alcohol, or weapons while out on bond.
And we will be asking for a no contact with the victims, Nukori Wright, Chris Barriers, Alicia Davis, and Deputy R.L. Coley.
Did you get that, Ms. Lewis? Oh, no, you don't have to. Make sure. Okay, thank you. All right, so make sure you got that. That's the stay away also, Mr. McLean.
Okay. I'll be driving over from the jail to my office to write it up, so there'll be a.
Okay, all right. Good luck to you, Mr. Blasingame.
Position 22, Mr. Jackson.
No, $1,500 a month. Oh, $1,500.
McLean, Helen has to give that.
And who's,
That's me, Judge.
okay. Position 22?
That's correct, Judge.
And this is your case, Ms. Helen?
Yes, Judge, can they repeat that position again?
Position 22, I've got down that there's a requested conflict counsel.
Oh, that is correct, Judge. Mr. Hill, as well as Mr. Jackson, are co-defendants with Mr. Young in the same case, Judge. So I represent Mr. Young, Mr. Hill, and Mr. Jackson will need conflict counsel.
Okay.
I sent that request in yesterday, as soon as I noticed that they were co-defendants.
Okay.
Right. Is there anybody else on here that need conflict attorneys? I'm not aware of it till now. Mr. McLean's the only, Mr. Burke's supposed to be on board on his counsel clients, but Cloud, I don't know how she's.
All right, so I see Mr. Murphy on, I see Ms. McLeod on. Would either of you like to take on the responsibility of representing Mr. Jackson? He needs a conflict attorney.
Judge, I'll be at your courtroom shortly and I'll take a peek at it.
All right, very good, thank you.
I should be there about 3 minutes.
All
Thank
right.
you, Judge.
All right, so we'll get you to speak with Mr. Jackson once you get here. All right, thank you. So if we can just hold on Mr. Jackson, and we'll have Mr. Murphy talk with him today.
We got position 11.
What's the announcement on Ms. Evely? This is position number 11. I have hold for announcement. Who's representing?
Judge, that'll be Mr. McLean's position and
Was that position number 11? Okay, very good. Let's see, that was to be announced. Was that the announcement earlier?
Yes.
So you were going to let us know. That's not him. Okay.
That's not him.
All
He's right here on the screen.
On the screen. Okay, there he is. Okay, more north. Mr. Evely, you were going to let us know this morning what you wanted to do.
You're on mute for North.
Yes, sir. I just wanted to make sure that all my charges were ran concurrent, the hit and run and the battery charge. Just want to make sure that everything is on the table before I take a plea.
All right, I don't have a battery charge on the calendar today. Is there, does he have a battery charge?
That's separate from this. If there is one, that would be separate from this. This was nothing but a traffic matter of a hit and run charge.
That's the state's understanding as well.
He has an open case, Judge. It's
Okay.
22 CP 214145.
Oh, well, that obviously would be in Superior Court.
Okay, so the only matter that we have before the state court, Mr. Everly, is your driving hit and run charge, misdemeanor offense. So would you like to move forward with that today?
Yes, sir.
And my understanding, I saw restitution as part of the.
The restitution would not be required, PD McLean.
Correct. Thank you. Do you understand that, Mr. Everly?
Yes, sir.
That was a major element we discussed yesterday, so. That's
The restitution?
Restitution's gone.
Yes, sir.
You are subject to civil suit if the other person thinks.
And just for the record, Your Honor, the state's recommendation is 12 months to serve, 32 days, credit for time served, 16 days, balance probated with a fine of $500 and a defensive driving course.
Right.
I believe
let me start. I haven't spoken.
I'm sorry.
Yes, it's not a problem. Mr. Everly, good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir, I do.
Thank you. Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. Anything further, Mr. Walker?
Nothing, Your Honor.
Mr. McLean?
I believe it sounds like he's asking the court to accept the negotiated plea. We discussed all those elements, including the defensive driving course.
Mr. Everly, it's my understanding that in case 22 CR 007916D, you wish to plead guilty to driving hit and run. Is that correct?
Yes, Your Honor.
Were you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir, I do.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Mr. Everly, I am going to waive the probation fees for you while you're on probation and help you get and stay on your feet. And when you pay the fine and complete the defensive driving course, the probation will terminate, okay?
All right. Yes, sir.
Good luck to you, Mr. Everly.
All right. Thank you, sir.
Thank you, Your Honor.
Who's next?
13 and 14, Griffin.
I can go ahead and sit down.
Ms. McLeod, have you had an opportunity to speak with Mr. Griffin?
I have, Your Honor.
What would he like to do today?
He wants to accept the state's plea offer.
He wants to accept the offer?
Yes, Your Honor.
Okay, thank you. Let's see. Good morning again, Mr. Griffin. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you. Mr. Walker?
Yes, Your Honor. The state's recommendation to count 3 will be 12 months to serve, 26 days. Credit for time served, 13 days, balance probated for the conditions of a FBIP course and no further contact with the victim whose name is Jamila Morris. Counts 1 and 2 will be null price in exchange for the guilty plea to count 3.
Okay, and maybe you said this, I don't know, position 14, you're null pricing that.
I forgot, Your Honor. Yes, that is correct. The state will be null pricing position 14.
Okay, thank you. Ms. McLeod?
Yes, Your Honor. That is our understanding of the plea offer, Your Honor.
Okay. Mr. Griffin, it's my understanding that in case 19 CR 010301J, you wish to plead guilty to simple battery family violence. Is that correct?
Yes.
You under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
Yes, sir.
I'll accept the plea as negotiated. Mr. Griffin, I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet. But you'll have to be on probation for the entire 12 months, okay?
Yes, sir.
Thank you, Your Honor.
All right, good luck to you, Mr. Griffin. Thank you, Ms. McLeod. The court appreciates you helping us out this morning.
I got position 18 and 19.
And whose case is this? I know it's a conflict.
They're gonna have to move it.
Oh, that's Mr. Murphy's
Mr.
case.
Murphy.
Mr. Murphy is assigned to those.
Okay, I think we're holding for Mr. Murphy on this case. And it's my understanding that he's headed to my courtroom at the present time. So can we take someone else until he arrives?
It's gonna be position 1, add-on, Mr. Blade or Bald.
Oh, yes, I don't know. I was trying to get the solicitor's office by phone call. I'd left a message to ask Mr. Walker to call extension 22392 so I could run that past Mr. Walker right before we take Mr. Baldy.
I'm not sure if I caught that. You were asking me to give you a call?
Yes, 22392.
Go back and have a seat, Mr. Bald.
22292.
No,
Okay.
2392.
2392. Okay. Well, do we need to move to another position? Well,
yes.
How would the court like to handle this, Your Honor?
Yes, we can move on to the next case, Judge.
Okay, well, we have to make sure that not Mr. Walker's case.
I have 1 through 15 in the add-ons.
Okay.
Okay.
Judge, I got position 28, 29, and 30.
Here we go.
And it's 28, 29, and 30.
That's correct.
Okay. And Ms. Helen, these are your cases?
That's correct, Judge. I have 21 through 41 and add-ons 2 and 3.
Okay, so I have down that 28 is going to be an arraignment and a bond hearing. None is going to be a negotiated plea, and 30 is going to be null pros.
That's correct, Judge.
Okay, let's do the, let's start out with the plea. Let's see. Can you hear me okay, Mr. Moultrie?
Yes, sir.
Good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Did you hear me?
Yes, sir.
Okay. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. Thank you, sir. Ms. Giddings?
Yes, Your Honor, as to position 30, we are asking the court to accept our null pros on that case. And on position 29, we're asking for time served and to stay away from the incident location.
How long has he been in custody? How much time is he going to be given credit for, I guess?
I have 12 days, Your Honor.
That is correct, Your Honor, 12 days.
And what's the stay away location?
3700 Martin Luther King Jr. Drive, Northwest Atlanta, 30318.
All right. Mr. Moultrie, I understand that I'm sorry, Ms. Helen, anything further?
Judge, that is our understanding of that plea. We do accept that plea from Mr. Moultrie, and we do stipulate the factual basis, venue, and ID.
Mr. Moultrie, it's my understanding that in case 22 CR 003937H, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Moultrie. Let's move on to position number 28. Now, if you can help me, Ms. Helen, I have position 28, Mr. Morton. Do we have more than one?
No, Judge, I just have position 28, Mr. Rico Morton.
Okay. Okay, so Mr. Moultrie was just position 29 and position 30.
That's correct, Your Honor.
Okay, all right. All right, have a good day, Mr. Moultrie.
You do the same.
Thank you. Who do we have next?
Position 40, Woods.
I thought we were going to do Mr. Morton's bond hearing.
Yeah.
Oh, you want to do it now? Yeah.
I thought I was under the impression, I was told it was 28, 29, and 30. When we looked at it, it was only 29 and 30. That was Mr. Moultrie's, so not position 28. So wherever the jail would like to go next is fine with you.
I have Mr. Moultrie here.
Okay, we finished with Mr. Moultrie, haven't we?
Yes.
Okay, so we're done with Mr. Moultrie. He's already, he's good to go.
Position 28, Morton.
May I get his bond, please? Good morning, Mr. Morton. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir. How you doing, Your Honor?
I'm doing well, thank you, sir. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Oh, my God.
Okay, you can put your hand down. Thank you. Mr. Morton, you've been charged in case 22 CR 007834F, the simple battery. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. Morton?
I do, Judge.
Thank you, Ms. Helen. How do you plead, Mr. Morton? Guilty or not guilty?
Not guilty.
We'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. I have that Mr. Morton was given on November 16th a $1,500 good bond. May I get his history, please?
11 cycles, last arrest, May of 2021 for probation violation in Douglasville. Underlying charge was not indicated. Record does reflect the defendant is on probation in Fulton County for burglary in the first degree, arson, first degree, under case 17 SC 151136, sentenced August of 2017 with 10 years probation. It is first offenders. And another open probation in Douglas County, identity theft fraud when using, possession, or identifying information concerning a person, 16 CR 00987A, sentenced October of 2017 with 10 years probation. Nothing further to add.
Ms. Campbell?
Yes, Your Honor. I also have, in addition to what pretrial noted, that this defendant has a 2011, at least an arrest. I'm not sure if it was a conviction for aggravated assault and cruelty to children. And that is relevant to the facts that I'm going to give the court on this case. I also have that he has a 2011 battery, as well as a 2016 infliction of pain upon a person over 65 years old. And so as pretrial stated that he's currently on conviction for very serious felonies, arson, which in the state's belief involves violence. This incident took place on March the 14th of this year at the location of 2500 Center Street at apartment C201. An officer was flagged down by a third-party witness to this incident. And upon further investigation, the officer did learn that this defendant, who was a 34-year-old man, he did strangle, choke out an 11-year-old little girl. Her initials are PC. And while he was choking her out with both hands, he actually held her over a second-story banister. And this incident was captured on video by the third-party witness. When the officer arrived on scene, the third-party witness did show the video of this defendant choking out an 11-year-old little girl to the officer. And by that time, the defendant had left the scene, but the third-party witness did get the defendant's tag number. So they were able to apprehend the defendant. The officers also learned that in order for this choking of this 11-year-old little girl to stop, a neighbor actually had to pull the defendant, another grown adult person had to pull the defendant off this 11-year-old little girl. And the force that was used to pull the defendant off the 11-year-old little girl was so great that the defendant's shirt was actually ripped off. And so, like I said, all of this is on video. So the reason allegedly for this very violent attack on this minor is because the little girl, the victim, did come over to the defendant's home to fight another minor child. And the defendant is the stepdad of the other minor child. And the defendant was arguing with the 11-year-old little girl who came over to fight his stepdaughter. And after they were arguing, that's when the defendant grabbed her by the neck, choked her with both hands. We did do a strangulation assessment, and the 11-year-old victim did state that she could not breathe. She kept trying to get away, but the more she tried to get away as she was being choked, the harder he pressed down. So we did try to have this transferred for aggravated strangulation. We were unsuccessful, however, but the state, whether it's in Superior Court or in state court, we do still take these charges, these allegations very seriously, considering the fact that it did involve a very violent attack on a little girl by a grown 34-year-old man. So with him having a $1,500 surety bond, the state actually doesn't even believe that that is the appropriate bond amount in light of the past history of violence. Like I said, he has an ag assault, a cruelty to children, a battery, inflicting pain upon people over 65 years old, which are also vulnerable members of the community, children, and the elderly. So the state does believe that he poses an extreme danger to not only the victim, but to the community as a whole. So the state actually recommends a $10,000 surety bond, no further contact whatsoever with the victim, PC, as well as a stay away from the incident location, which is 2500 Center Street, apartment C201. And we have had contact with the victim, and she states that she does not want him coming near her. Nothing further.
Ms. Heller?
Yes, Judge. Today is a bond hearing for Mr. Morton. You've heard his history. I believe you've also read the warrant and the police report. ASP Campbell is really speeding over how a 11-year-old, apparently a minor child, thought it was okay to go to apartment C, which is listed on the warrant. They don't even live at that address, Judge. So this alleged victim came to Mr. Morton's home to offer violence to whoever lived there. And so the state wants to try to narrow it as it was focused at another 11-year-old. No, sir, it was not. It's whoever answers this door. And not only did she show up with herself, she showed up with someone else. The alleged witness who showed a clipped video of Mr. Morton trying to defend himself. So let's talk about what happened. Miss PC showed up to the door offering violence to another child there, his child, by marriage. And Mr. Morton is trying to defend not only himself, but his child at the doorway. So he's telling this young lady, please leave, please leave. Okay, she refuses to, and then she assaults Mr. Morton at his own home. This is apartment C that's listed. Mr. Morton does not have the history to do that. And so let's go into the history that was mentioned. The ag assault and the cruelty to children actually occurred in 2011, allegedly, and they declined to prosecute, Judge. So we're just going to clarify this history. He does not have this history of a long-standing violent offender of anyone. And also with those probations, Mr. Morton went to the police with his own video recording PC, as well as the other young lady that she brought to their home to fight whoever was there. That video shows he's asking her to leave. He shows this to the police. They don't arrest him, Judge. He goes in March. He goes as soon as it happens. They don't arrest him. They let it go. If you actually look at the warrant, it was taken out May 6th. So I think there was a failure of investigation here. This is alleged accuser is a violent young individual and showed up to this address offering violence to Mr. Morton, who tried to push her away from their doorway, not over a banister, Judge. He showed the video to the police in March, not over a banister. Please leave us. Please leave this location and completely leave us alone. And so when he went and showed and told the police in March, they did not arrest him. They let him go. But then put out a warrant from a clip video from the other minor who was invited to the attack, Judge. We're asking for a signature bond. He doesn't have any other history of violence towards anyone, Judge, anyone that he knows. And so let's get into his history. He's 34 years old. Okay, he has 10 children. His one stepdaughter is one of 10, 5 girls and 5 boys. He's the primary caregiver of all 10 children, Judge. He's a chef manager. He also believes his job will be waiting for him when he gets out because, again, they understand he's not a violent offender and they want him back at that job, Judge. He also is looking to get his GED, Judge. Also, he has a long supportive history here in Georgia with his family. Mom and dad are lifetime residents in Fulton County, Judge. We are asking for that signature bond. We are not going to necessarily talk about PC, but from the information that I have from my client, she has a long violent history and currently she's incarcerated.
Okay.
So, Judge, we are asking for that signature bond. And if you feel that he is ineligible for the signature bond, we're asking for a bond no more than $500 short.
Judge, I just wanted to clear up. He does have violent arrest, just not showing any convictions.
Several.
2012, he has battery, family violence. 2010, battery, visible harm, family violence, battery, visible harm. He has a 2008 which is aggravated assault, assault with intent to, it's a CWAC charge. Well,
A rape was a rape as well. And
Oh,
ag assault.
I thought we were.
Decline to prosecute.
It's okay. It's okay.
Okay,
all his arrests are violent, Judge, just no conviction.
We
And
just
Your
need to
Honor-
does that no conviction part, Judge.
Your Honor, I would like to give a brief rebuttal. The Ayala factors ask the court to consider whether or not he's a danger to the community. And Your Honor, his prior arrests, whether they're convictions or not, they do go to the behavior that he's committed while out in the community, allegedly. Whether there was a conviction, whether the state decided to move forward or not, these are all violent crimes that he's been accused of during his time as a member in the community. And in light of the fact that here he's alleged to have violently attacked an 11-year-old girl, whether she incited the attack or not, whether she came to his home or not, she's still a child, an 11-year-old child, and he is a 34-year-old grown man. That's not reasonable behavior for any member of the community. And it does give the state great concerns about the safety of the community as a whole. So that is why the state brought up the prior arrest, because that does go to the Ayala factors.
okay, I'm gonna leave the bond where it is. Good luck to you, Mr. Morton. Who do we have next?
Got position 30.
Position 30 is Mr. Moultrie, and that was Noel Prost. So who is this?
Position 33.
Okay. And that's Mr. Patatan Quitter. Is that right? All right. Good morning, sir. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Can you hear me, sir?
Yes, yes,
Okay. And you agree to have your case heard by video?
yes,
Okay. Raise your right hand for me, sir. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
yes, sir.
Okay, you put your hand down. Thank you. And this is going to be a non-negotiated, Ms. Helen?
That's correct, Judge.
All right. What's his history? Ms. Harrison?
One moment, Judge, checking now.
One four zero zero. The pass code.
10 cycles, last arrest, April of 2021 for a probation violation in Fulton County. Underlying charge was not indicated. Record does indicate an open probation in Fulton County for aggravated stalking, 19 SC 173276. Sentenced November of 2020 with 4 years, 3 months probation. And an additional open probation for aggravated assault, strangulation, and bad burglary in the first degree. 20 SC 176711, sentenced November of 2020 with 4 years, 3 months probation. Nothing further to add.
Okay, thank you, Ms. Harrison. Ms. Giddings?
Yes, Your Honor. The state's offer was 12 months to serve 90 days, credit for time served 33 days, balance on probation for the defendant to complete the DVIP course and to have no further contact. The facts in this case are that the defendant was smoking at home on the inside of the home, and his father asked him to go outside. The defendant did not particularly appreciate being asked to step outside to smoke and began to punch his father in the face. A different family member within the home had to break up the altercation. I'd like to point out that the father did not fight back. He just kind of stood there and took it. police were called and the defendant ran and hid behind the apartment complex where he was located. The history that I have also includes a FTA in 2017, a probation violation in 2017, a possession of marijuana less than an ounce in 2017, driving without a valid license in 2017, shoplifting in 2017, as well as a driving without a valid license in 2016. Nothing further, Your Honor.
Helen?
Yes, Judge. I just wanted to update for the jail time. Mr. Richard agrees to probation.
Serious Griffin too. Okay, so 12/2/22.
Ms. Lewis, Mr. Murphy, we can hear you all. I apologize. Go ahead, Ms. Helen.
He agrees to the probation, but he's been incarcerated since for the last 39 days. He was booked in October 29th, 2022. Judge, we are asking for that to be time served. I've spoken to Richard. He agrees. He's wants to resolve this case in that family violence intervention program. And so, Judge, he is really remorseful for what happened, but he really wants to do that program, but we are asking for time served.
I'm going to take the state's recommendation if he wants to plead to that, Ms. Helen.
Richard, that's going to be 6 additional days. Do you accept it? And it's also going to be with those probation conditions.
You don't have to download it.
We don't have a problem with the additional 6 days, Your Honor, for credit.
It's just the internet stuff.
Richard,
Yeah.
do you agree to do 6 additional days in the probation?
Yeah.
Yes, Judge, he does agree.
Okay. Mr. Patton Quitter, it's my understanding that in case 22 CR 007560D, you wish to plead guilty to battery family violence. Is that correct?
Yeah, yes.
Are you under the influence of any drugs or alcohol at the present time?
No.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you've given up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea. Mr. Patton Quitter, the sentence will be 12 months to serve 90 days, credit for time served 39 days, balance probated, DVIP course, and no further contact with the victim. I'm going to waive the probation fees while you're on probation to help you get and stay on your feet, but you'll have to complete the entire 12 months on probation, okay?
Okay.
All right, good luck to you, sir.
I appreciate it.
Position 40, Woods.
Okay, this is going to be arraignment and a bond hearing.
That's correct, Judge.
Good morning, Mr. Woods. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
This is not Mr.
Woods, Thomas Woods, position 40. No, it's not him.
So let's just pause. Can you?
Judge, we're gonna move on to the next case. This is not the right person, Mr. Woods. It's a different
Okay.
Woods. So go ahead and have a seat.
Yes.
Mr. Woods.
Moving on, Judge, we're gonna go to position 21, Mr. Hill.
Okay.
Until
And we have a conflict attorney for Mr.
We take that to the, ask Mr. Murphy to take the co-defendant on this case.
Okay. So, Ms. McLeod, is this Mr. Hill, your client?
Your Honor, no, I don't believe he is my client.
Okay, we are in need of another conflict attorney, this morning, Ms. McLeod. Are you willing to take on Mr. Hill's case?
Yes, Your Honor.
Okay, so can we have, Mr. Hill speak with, Ms. McLeod and,
Okay.
update her with the,
Ms. McLeod, you have the contact number? It's gonna be 404-612-2392. You can have a seat at that.
2392? Okay, I'll call.
92. Thank you, Ms.
Thank you.
McLeod.
You're welcome.
We go to position 41, Judge.
okay? And, this is Mr. Young,
That's correct.
okay? And this is gonna be a negotiated plea, Ms. Helen?
That's correct, Judge.
All right, good morning, Mr. Young. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, sir? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can put your hand down. Thank you. Ms. Giddings?
Yes, Your Honor. For the criminal trespass, we're asking for time served and to stay away from the incident location. And on the loitering prowling, time served. Mr. Young is one of 7 people, which is why you need so many conflict attorneys this morning, that found themselves entering upon a home under construction. The police were called by a neighbor who saw several people going onto this site and wasn't quite sure what was happening, and everyone was arrested without incident.
Okay, how much time has been served?
According to what I have, 16 plus 18 days, unless somebody has something different.
Mr. Young?
Yes.
22 days so far, Fulton County Jail as of today.
22 days is what, Ms. Lewis is telling me.
Okay.
That's what I have too, Judge.
Okay, anything further, Ms. Helen?
No, Judge, we do accept that offer. That is our understanding, and we do stipulate to the factual basis, venue, and ID.
All right, Mr. Young, it's my understanding that in case 22 CR 007810E, you wish to plead guilty to criminal trespass and loitering and prowling, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
Okay.
Is that a no?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, I understand, sir.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Young. Good luck to you, sir.
Thank you, Judge.
Position 4, Mr. Clark.
This is just going to be an arraignment.
Yes, Your Honor.
Good morning, Mr. Clark. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
No.
Okay, can you raise your right hand for me? Do you swear? Keep it raised. Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you. Mr. Clark, you have been charged in case 22 CR 004593Y with theft by shoplifting. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. McLean?
We do.
How do you plead, Mr. Clark? Guilty or not guilty?
Not guilty.
We'll record your not guilty plea. Your case will be returned to the division judge, and you will get notification of your next hearing date. Good luck to you, sir.
We have position 9, Mr. Daniel.
This is going to be a negotiated plea.
I believe that's correct. Let's see, Daniel. We'll grab the right. Here it is. Yes.
Okay. Good morning, Mr. Daniel. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. Mr. Walker?
Yes, Your Honor, the state's recommendation is 12 months to serve 60 days, balance probated, and a 6-week anger management course. And we're going to ask for a no contact with the victim, Takia Wilcox.
Are you giving him credit for any time?
He hasn't served any time on this charge, Your Honor, so no.
Okay. Mr. McLean?
Your Honor, let me check with Mr. Daniel. Mr. Daniel, is that your understanding about the 60 days to serve? And when you get out, it'll be a 6-week anger management, is that correct? The 60 days with good behavior will be 30 days.
Can you hear counsel, Mr. Daniel?
Yes, sir.
Okay.
Is this your understanding of the plea?
Counsel is asking you if you understand the negotiated plea terms.
I'm kind of lost because I just heard the DA has said that I didn't have any jail time, and I do have jail time. I just did a year in here and got out in February and just did 9 months in drug court. So I'm trying to figure, now I'm kind of lost because I'm trying to figure out what am I being charged with?
This is a battery charge, Mr. Daniels. Mr. McLean, it seems to me that since he's not understanding and that the state is asking for 60 days, I believe that you need to speak with him further regarding this matter. And I'm willing to place this on my next calendar next Tuesday if you want time to do that.
Completely agree, Your Honor. Thank you.
Okay, so we're going to reset your case until next week, Mr. Daniel, so that to give counsel an opportunity to confer with you to make sure that this is what you want to accept. Okay.
Yes, sir. Thank you.
All right.
And Your Honor, just to provide clarity to counsel, he's being held on, I believe, separate felony offenses. The case that's before the court this morning was initiated as a citation only case, so he was never booked on this charge. And that might give some clarity to.
Okay.
Correct.
Okay, thank you, Mr. Walker. And Mr. Daniel, Mr. McLean will be in touch with you, so you can ask him whatever questions that you need before next week, okay?
Yes, sir. Thank you.
Okay, you're welcome. I'll see you next week, sir.
Going back to add-on 1, Mr. Baldy.
Okay, and who's representing Mr. Baldy?
I do, Your Honor.
Okay. This is going to be a negotiated plea?
Yes, Your Honor. Now, there's a person on the iPhone who says that he is Mr. Baldy. There was a discussion of the correct name, and this is a traffic case of an expired tag from the date in question. So it's not, it's a relatively minor case compared to some we see. But there was confusion about the name, and my client's story was simply that he was, when pulled out of the car or when asked to get out of the car, whatever it was, he was confused and he was mumbling, and the owner of the car's name is Mamadou Baldy. And so the police officer put down that name and he was booked into this jail. He says that the clerk's reading of his cycles in the GCIC was correct. That would be Ebenezer Koki, and that is the correct name, and his correct record was read. However, the jail still has him down as Mamadou Baldy and does not have an alias listed as Ebenezer Koki. So he said, well, here's the phone number. So I called Mr. Baldy and the phone number, and I said, do you have the IDs? Can you show them to us on camera? Or are we gonna have to get them some other way? Can you hear me, Mr. Baldy?
I'm sorry, Your Honor, what's the announcement again? Because I thought it was a plea, but this doesn't sound like a plea.
No, it's
so hold on. So you're telling me, Mr. McLean, that this is not Mr. Baldy sitting next to you? His
Yes.
name is something else,
His
right?
name- Right. The thing is, his friend loaned him the car. He got charged with the expired tag and the false informations.
No, I understand. I understand. I don't mean to interrupt you, Mr. McLean. I understand all that. So are these accused under Mr. Baldy's name?
If they are, Your Honor, and that's who
Okay.
the defendant is booked in as.
Okay, and do we have the proof that he is E. Pope? Is that what you're telling me that this gentleman is, Mr. Pope?
Kokie, Cockie.
Oh, spell the last name again?
I'm sorry, Kockie.
So this is Mr. Kokie.
Right.
Right, and I checked Odyssey, and according to the notes that we have in our system, it was that Mr. McLean was supposed to be providing some type of proof or documentation that this is not Muhammad, or Mr. Baldy, is in fact Mr. Coke. I have not seen any documentation. Again, the defendant is charged with 4 different counts of giving false information to a police officer because he lied about his name 4 different times. So again, the announcement is a negotiated plea. This doesn't sound like a negotiated plea. I understand that someone is on Zoom with the ID that I cannot read or make out, and the state is not changing its position. So I'm not sure where we're going with this.
Yeah, it's a negotiated plea. He just wants to get the time served for the traffic offense. If he just didn't want to do the disservice to his friend who loaned him the car, of messing his name up.
Well, first of all, we're gonna have to have the right person's name for the plea, right?
Right. He's booked
So-
in jail under Muhammad Baldy, so I'm not.
Okay, so Mr. Baldy, I see you there. You're telling us you're Mr. Baldy and he's not Mr. Baldy, so
Correct.
I don't think there's any discrepancy that this man is Mr. Kokie is not Mr. Baldy. So I appreciate you being here and being willing to let the court know that your name is Mamadou Baldy. So thank you, sir. Mr. Kokie, we're gonna have to, we're gonna have to get the man's correct name and on an accusation, right, Mr. Walker?
I mean, that's correct, but just because the defendant says his name is Mr. Coker, again, he's trying to.
I understand
And give
that.
false information, so he could say his name is
My name is-
John Smith.
My name is Mamadou. My name is Mamadou Balde.
I understand. I was referring to the person in custody, but I agree with you, Your Honor. If what he's saying is correct, we would need some type of documentation to prove his true identity, because the defendant could theoretically say his name is Ian Walker. That doesn't make it true. So without any documentation, which I have in my system that Mr. McLean was supposed to provide today or by today.
Right, we had this on Thursday.
I'm not just going
Unfortunately, I was not able to reach Mr. Baldy until Mr.
I
Walker.
am here.
I understand that his name is not Mr. Baldy, but what I'm saying is I have no proof that his name is Mr. Coker either. He can say that his name is Ian Walker. That doesn't make it true.
Okay, I understand all that. So what are we gonna do with this gentleman that's sitting beside Mr. McLean this morning? Mr. McLean, are you able to verify to the court or to Mr. Walker, the state, who this gentleman is in any way?
I have no documents, Your Honor. I was just able, in the last few minutes, I've been trying all this morning when he gave me the phone number. And only on the last time I tried a few minutes ago did I reach Mr. Baldy. I said, zoom in. And if you've got something we can see, you might have to come down to court.
That's good. That's all nice and good and all. I don't care about Mr. Baldy over there. I care about who's sitting beside you that's in custody. So we have to have that man's appropriate identity.
Right, and I believe the identification card for Mr. Kokie may be at Mr. Baldy's house. I don't know. Mr. Baldy,
Mr. Baldy, who are you to Mr. Kokie?
Mr. Koki is my friend. We used to live together. We live in together.
Oh, do you have any identification for Mr. Koki?
Hello?
Sir, did you hear my question?
No, I don't have it. He has his identification on his phone. Yes, yes, he has his identification on his phone. He has his own driving license, his phone.
I'm sorry, I can't understand.
His name is Ebenezer Koki.
Okay, so do you have any proof of that?
I say he has yes, he has his name even license is valid. He has it in his phone. He take a pic, he has his phone.
Who has his identification card?
Can I say something?
Hold on. Mr. Baldy, do you have his
Yes,
identification?
Ms. Harrison.
Okay, so he may have used his friend's name, but once he was in the jail and they live scanned him, his identification came up. So I do have his GCIC and it's who he says he is.
Okay, so we have something that verifies that his name is Ebenezer Koki.
Correct.
Correct.
All right, so what we're gonna have to do, I believe, and you'll tell me if I'm wrong, you're gonna have to redo the accusations. Since it's verified, so that we can move forward with the plea if that's what he wants to do.
That's correct, Your Honor, and I think that's the easy part, but I think what still needs to be addressed is that he's booked in the jail under a different identity. So I think there's additional steps that will have to be taken at the jail to book him in under Ebenezer Koki.
Well, they added this name as an AKA to his profile, but his information is still the same GCIC.
I understand, but he's booked in as Muhammad Baldy. So yes, I can very easily draft an amended accusation, but I believe that he needs to be rebooked under the correct identity, if that makes sense.
Yes.
I can draft the accusation in less than.
All right, so I can do one or two things. Give you the time to do that or reset this for Thursday so y'all can work all this out.
The state will request a reset to Thursday, and if Mr. McClain can email me the exact spelling of the name, I'll be glad to.
Yeah, I don't have any documents, but it is Kokie. And Ebenezer is the regular spelling.
Your Honor, this is ASG Giddings. If I may interject, because I had this similar situation not too long ago. And because an alias was used for the gentleman that's been showing his ID card, if the jail does not rebook him, it's going to create an alias for the gentleman who was not booked in. And if anything were to ever happen, it's going to come up as if he used Mr. Koki's name as an alias. They're going to be intrinsically linked unless Your Honor issues an order to the jail that the gentleman that's sitting next to PD McClain actually rebook him under the right name and remove the alias so that we don't have an issue with the gentleman who is listed as iPhone on the screen. I think that was ASG's Walker concern, because we're creating a criminal record for someone who was never arrested.
Well, that was Mr. Kokie's concern as well. That's why he didn't want to but his own. But
yes,
could he
exactly. But the jail is not going to do a rebooking absent a court order.
Right now.
Okay, so Mr. McClain, can you draw that order up for the court?
I'll draw an order up for the court, Your Honor. Is there any way he could be free in the meantime? Because we reset it since last Thursday, and he's just sitting here. And it's an expired tag case.
You reset it from last Thursday?
Yes, Your Honor.
Well, you all should have gotten this handled, because if this has already been on the calendar between last Thursday and today, I mean, why would we come back here with the same type of issue?
Exactly, Your Honor. We were only able to reach Mr. Baldy today during court.
But if
And
this
I'd like
man,
to clarify
all
that
right.
when he says we, he's not referring to
I
the
am
state.
here, Mr.
All right, I'm
Bond.
sorry, but there's a lot that needs to be worked out here, so we're gonna reset this back to Thursday. Maybe it'll go back to the same judge that had it last Thursday to deal with.
Very good.
All right. Good luck
And
to you, Mr.
I
Koki.
am here.
just to be clear, the state will be waiting for an order from Mr. McLean that we can jointly present to the court on Thursday. And I will have the accusation amended accordingly by Thursday.
Right, and Mr. Baldy, I'm going to need to get in touch with you so that I can get those IDs. But I might be able to do it just with what the clerk has. Thank you.
I am here, Mr. Balde. I am here. I have my ID here.
Okay, thank you.
All right. Who do we have next?
Position 18 and 19. Position 18 and 19.
Are you ready, Mr. Murphy?
I am, Judge.
I
Okay.
am here.
And what are we gonna do with Mr. Harris this morning?
Judge, this was a case where Mr. Harris had court with Judge Edie back in October. And he did not appear. And then he subsequently got in custody. Your Honor, I would ask that the state has made a recommendation, several recommendations. I have discovery. Judge, I'd ask the court to allow Mr. Harris to go back out on the existing bond for case number 20 CR 005-991Y. Mr. Harris was almost 19 years of age when this alleged incident occurred. Under the change of the law, I believe he would be exonerated under that charge. Mr. Harris contends that back in April of 2021, his mother had passed away, and so he was no longer at the Vesta Drive address that was on file, and that he resides at 532 Cleveland Avenue, Atlanta, Georgia, 30351. He resides with his uncle, Dion Hamilton, and that he would report to court as directed. Again, given his age, he's been in custody a total of 18 days now. I would ask the court to consider allowing him to go back out on the existing bond.
Okay. I'm gonna do what I normally do in these cases, Mr. Murphy. Given that it was Judge Edie that he missed court with, and Judge Edie is the one who issued the bond, I'll have him go back to Judge Edie for bond modification if that's what he seeks. Okay.
Yes, Judge, and then I'll file a motion. Thank you, Your Honor. I appreciate you.
And so, Mr. Harris, I'm going to send you back to the division judge so he can address your bond modification. Okay, so you'll get notice of when that date is going to be. Okay.
Hello. Excuse me. Now I'm saying if my normal bond is still on there, right? Though I can still bond out on my normal bond that's in the system, right?
You'll have to go back to Judge Edie because he issued, it's my understanding that he issued a new bond. All right, good luck to you.
Judge.
Yes.
Judge, he was given bond by this court back in, it would have been right around December 12th of 2020. I represented him then.
And Your Honor, if you're going to consider bond today, the state would definitely like to be heard on this case. The state has a lot to say about this case.
Okay, again, I'm going to follow my normal practice. If another judge entered a bond order, I'm going to have him go back to that judge for modification. Okay, so.
Judge, yes, Your Honor, and I respect that. I'm just saying that that this court sets the bond initially. Right. And it was subsequently, once the case reached Judge Edie, when he missed court in October.
Right, and I think that's the way it normally happens, right?
Okay, yes, Your Honor.
Okay, all right, so again, he'll have to go back to Judge Edie for modification, even though this court did initially set it.
Back to Judge.
Okay, Mr. Harris, you have a right to remain silent. Anything you say can be used against you. You will get the opportunity before another judge to modify the bond. Okay. All right. So who do we have next?
Position 32. Position 32.
What was it? And this is going to be a
Negotiated plea, Judge.
I have this is Mr. Person,
That's correct, Judge.
and I have jail jury bond hearing on the sheet from this morning, but you're telling me now it's going to be a plea?
I apologize, Judge. I was looking at another position. This is Shaman Pierce, position 31. That's a negotiated plea.
Okay, I was told that it was position 32. So. see-
Oh, I'm
see-
sorry. He's on jail court's iPhone. I apologize. I thought we were calling the person next to me.
Okay, so can you hear me okay, Mr. Person?
Say it again.
I said, can you hear me okay?
Yes, sir.
Okay, I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes. Yeah.
Thank you. Mr. Person, you've been charged. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Mr. Person, you've been charged in case 22 CR 002651A with battery family violence. This charge carries a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen?
I do, Judge.
How do you plead, Mr. Person? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Do we have his bond? Thank you. Let's see. Did he miss court? Because I gave him a $3,000 signature bond through pretrial.
No, Judge, there's a rearrest, or not a rearrest, but a new arrest.
Oh, so they withdrew the bond when he was rearrested?
Yes,
that-
Judge, it was surrendered.
Okay, the bond was surrendered when he was rearrested. So when I normally set a bond of an amount, I anticipate, that if they're rearrested and it's withdrawn, that in this case, the $3,000 will be what the bond will be. Is there any reason that I shouldn't keep this as a $3,000 $3,000 good bond?
Yes,
Your Honor, that was going to be the defense's I'm sorry, that was going to be the state's recommendation.
Okay, thank you, Ms. Giddings. Ms. Helen?
Yes, Judge, I was gonna have a bond hearing for Mr. Person. We're asking for that $3,000 to be modified back to a signature bond. When I went and spoke to Mr. Person, he has just been recently arrested for those new charges. And when I spoke to him, when he was arrested, what's the date for the new charges? Because Mr. Person believes those allegations occurred April 29th of 2022. And I'm sorry, is Mr. Person on screen? I can't see him.
He was on the screen. He was on an iPhone. I believe it's jail. I don't see him
I don't see him now, but he was just there.
So what you're saying, Ms. Helen, was that he had, this charge was from April 29th of 2022. When were the other charges?
And Judge, that's what I'm trying to get more information on. I didn't see an incident date on Odyssey. If the state or pretrial services could give me a date for those new allegations.
Ms. Harrison, are you with us?
Yes, Judge, one moment. I'm sorry. What is going on?
Ms. Helen is in inquiry of when the new charges, when he was arrested for new charges. That subsequently his bond was withdrawn on.
Are we discussing persons?
Yes.
Okay, one moment.
Was surrendered on.
Yes, that bond was surrendered September 12th.
And did he pick up new charges?
He did. He has an open felony with non-bailable charges.
Okay, so this is irrelevant at this point in time. So it's gonna remain a $3,000 good bond.
I'd like Mr. Person to come back so I can tell him that. I just don't see him on the screen.
Okay, if he comes back, we'll allow you to tell him that.
Thank you, Judge.
Okay. All right.
Your Honor, may I interject real quick, please?
Yes. Who's speaking?
This is Mr. Person. Your Honor, the case, the date on the case that it inquires is actually happened before the before this case. The allegations of the dates was before this case.
And Judge, I don't have a history of appearance for this attorney on this case. I just want to make sure that this is a person is appearing for person on this case.
Yes.
Okay. I didn't see an entry entered in Odyssey, so I just was kind of confused.
No.
Yes.
Would you identify yourself and who you are to Devin Person?
I'm Danny Person. I'm Devin Person's father.
Okay, so you're not. Yeah, you are appearing here today as his dad.
Correct, but I was trying to clear the case of the dates you were inquiring about. The alleged arrest wasn't after the this arrest wasn't happened as a result of the first arrest. This alleged crime that they arrested him for happened prior to this case today.
It appears, Your Honor, that the case that Mr. Pearson, the father, is talking about, the offense date is prior to April 29th of this year. He just wasn't picked up on it until after he was picked up on this, from what I'm seeing.
Okay.
It's a little confusing, but it appears that the incident date of the case that the father is talking about, I understand that pretrial surrendered him. However, the timeline needs to flip. They're thinking he picked up a new charge. He did not. That charge was already there. He just hadn't been arrested on it. It was already out there. They just hadn't found it to pick him up.
Right, but it's a new arrest.
I'm sorry.
It's still a new arrest. He wasn't in custody at the time, so yes, pretrial surrendered that bond.
Yes, I understand that, Ms. Harrison, and you're absolutely right. I think the father's point is, which is going to be my point, when he was arrested on 4/29/22, it should have flagged that there was something out there, and it did not. So it is a new arrest, but not to any fault of the defendant. It was in the system. Somebody just missed it. So I understand why pretrial came off. Yes, because it's a new arrest. I think the father's point is, and now the state's point is, it should not be a new arrest because they should have got it and flagged it and pulled it when they picked him up for 4/29/22.
So it's a state's position that that I should give him a signature bond.
I will defer to the court with that, but our position is that if we missed it, and we meaning whoever processed him at the jail and however that took place, didn't realize that there was also something out there, we should not treat it like he went and did something after this, like a new offense. The offense was already predated of this one. So we would not object if the judge, Your Honor, decides to reinstate his signature bond.
Okay. And it's also my understanding, even if I reinstated the other charges that he is being held on, he's been held without bond. Is that right?
Yes, Your Honor, he is being held without bond. And so when he goes to arraignment for that, it will have to be addressed then.
Okay. So,
and I don't know, Ms. Harrison can correct me, if they would, if pretrial will take him back, it may have to be a signature bond through the jail.
Pretrial will not take him back. He has that open case.
Okay, so yes, it would have to be a signature bond through the jail.
So, thank you, Ms. Giddings. And Ms. Helen, it's going to be a $3,000 signature bond through the jail. And can you make sure that all the other conditions of that previous bond are listed?
Thank you, Judge.
All right. Thank you, Mr. Person, both of you. I appreciate you clarifying that. Okay, who do we have next?
Position 31, Pierce.
This is going to be a negotiated plea.
That's correct, Judge.
Good. Morning, Mr. Pierce. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony that you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Sir.
Okay, you can put your hand down. Thank you, Mr. Pierce. Ms. Giddings?
Yes, Your Honor. The state's offer on this case is to ask the court for a sentence of time served and ask that Mr. Pierce stay away from MARTA. He has an open and active prior criminal trespass warning from June 22nd of this year, and his suspension runs through August 16th of 2023. So starting August 17th of next year, he can resume riding MARTA. This incident took place at the 5 Points MARTA station on the northbound platform, where he was seen by MARTA police officer Chardon, and he was asked to collect his things and to leave the station because he was under a criminal trespass warning and was not supposed to be there. And he refused to do so, and hence he was arrested. Does the state stipulate to a factual basis for the plea, venue, and identity?
Yes, we also do accept this plea on behalf of Mr. Pierce.
Do we know how much time is served?
He's been there 16 days, Judge.
Yes, 16 days, Your Honor.
Mr. Pierce, it's my understanding that in case 22 CR 0079088, you went to plead guilty to criminal trespass. Is that correct?
Yes, sir, it is.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir, I do.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Pierce. Good luck to you, sir.
Thank you so
Thank you,
much.
Judge.
Thank you, Your Honor.
Judge, I have position 22.
Okay.
Not see you back here.
That's Mr. Murphy's case, I think, and he has stepped outside of the courtroom. So I think that is supposed to be talking to,
We can go to position 20, Judge.
okay.
Judge, if you can send me to a breakout room for Jackson.
Okay, so he's just left, so
Okay.
I'll get you into a breakout room as soon as I deal with this gentleman. Who do we have?
Position 20.
That's not position 20. This is Javon Woods. So he's gonna be
No,
at
we're-
the back of the
We're
calendar?
at 4 North.
Oh, thought we were calling this gentleman.
Okay, so who's representing Mr. Herrera?
Okay, here we go. I would love to represent Mr. Herrera. He does not have any English, so we need the Spanish interpreter.
Yes, sir, I'm here.
Yeah,
Right.
Madam Interpreter's been here all morning, so we appreciate that. I'm sorry.
You're very welcome here.
Okay, so I guess we will, I don't know how we're gonna do this, Mr. McLean.
It is a mystery to me how we're gonna do that other than, I don't know how the phone arrangement would work or if we have to meet at the jail to do this.
No sé cómo vamos a poder arreglar esto. Tendremos que reunirnos en la cárcel o ver qué opción hay.
When I met Mr. Herrera at the jail yesterday, we could not communicate. I wrote things out. He does not have enough English to understand these things.
Oh, okay, so I understand that, but how are we going to do that, given that you are in, you are where you are and he is not? Is there any way for us to get Mr. Herrera to Mr. McLean, or is that not possible?
Yes, that's possible, Judge.
Okay.
I'll
Okay.
just have, yeah, he'll just have to, Officer Richardson, will
I'll
have
bring
to
it to the judge.
bring him down to the courtroom.
Okay, and then will that be satisfactory for you, Mr. McLean, to speak with the
Well,
interpreter?
that will be fine, Your Honor. Also after this, Toy Clark, TOY, is on a different floor. I was not able to see her yesterday.
Females, okay.
Well, let's just deal with this.
Gotta call South
Yeah,
Bend.
and we'll-
They just called.
Okay, so we'll get Mr. Herrera to courtroom 2. Thank you. And would you just let him know, Madam Interpreter, that that's what we're going to do?
Señor Herrera, van a ponerlos en la sala 2, lo van a traer para que pueda hablar y su abogado está ahí presente.
So can y'all bring?
Yeah, he's gonna bring him down.
Okay.
All right, thank you.
Yeah, well,
That's his South Phoenix, you gotta call.
Okay, and so at 4 North, we still need to put Mr. Murphy into a breakout room with the last person that was there.
Yes, I was about to inquire about that breakout session.
Okay,
Oh, he's just gonna have to bring him down, Judge. Richardson, you just gotta bring him down.
No, this is somebody else. This is Mr. Jackson.
right.
Look, you can't do the breakout because you're gonna hold the cases for the other cases. You gotta bring him down.
Okay, so you all want him to bring Mr. Herrera to you now before Mr. Murphy goes into a breakout room. Okay, so 4 North, if you'll just do that, Mr. Murphy, if you'll just hang on until they get back with your client at 4 North, and we will continue court in either courtroom 2 or the South Annex. Appreciate your patience this morning, Madam Interpreter. All right, so where are we gonna go?
We can move on to position 40, Woods.
Okay, so who's representing Mr. Woods? Is that you, Miss?
Yes, Judge, it is.
This is gonna be an arraignment. Is that right?
And for Mr. Woods, that's actually going to be, hold on, Judge. I apologize. I'm just looking through my notes. Yes, Judge, that's going to be a arraignment and a bond hearing.
Okay, good morning, Mr. Woods. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Woods. You've been charged in case 22 CR 007145F with simple battery. This charge carries a maximum penalty of 12 months in jail and or $1,000 fine. Do you wait for a reading of the accusation?
I do, Judge.
How do you plead, Mr. Woods? Guilty or not guilty?
Your Honor, please forgive me. I need to interrupt here because an amended accusation was sent to the clerk's office on yesterday on Mr. Woods' case. He's no longer charged with simple battery. He's charged with simple assault.
Okay.
penalty is the same, but it's not simple battery, it is simple assault.
All right, and is there another case number?
No, it's the same
Oh,
case
same
number.
case
Your Honor.
number. Okay, thank you, Ms. Gaines. So he's been charged with simple assault. Ms. Helen, and do you still wait for formal reading of the accusation?
I do, Judge.
And how do you plead, Mr. Woods? We'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Okay, so let's see what happened with Mr. Woods. I gave him a signature bond, $3,000 signature bond on October 24th. Did he, was this bond surrendered?
It was, Judge. There's a new charge.
And what new charge?
I believe it's burglary.
Okay, and is there, and what's the reason that I should modify the bond?
Judge, again, we're asking for a modification in this because number one, Mr. Woods is 24 years old. He has no children, but he has received his GED from online courses. He is employable, does have a job. I believe that job is still going to employ him once he is released. He's been working that job for the last several months. It is a tire shop. He is from Michigan, Judge, but he has been in Georgia for the last 7 years in Fulton County. He has a brother, Mike Hutchinson, here in Georgia for family ties. He also has many other friends that he's made in Fulton County, Judge. We are asking for a reduction to no more than $1,000 surety for Mr. Woods. In this particular case, I'm glad that it was newly amended because when I spoke to Mr. Woods, he stated he made no contact with this individual. He spit, but he turned to spit to the left. He made no contact with any person. So I'm glad that that was actually amended. But the thing is, Judge, this was a MARTA incident. He was speaking to this MARTA employee to get a refund for a Breeze card, for a $5 Breeze card. There was some type of spat back and forth. He spit and that was it, Judge. So we are asking for a reduction to no more than a $1,000 surety. And we are also really just begging this court to understand that Mr. Woods really would like to re-enter our community. And so he would like to be awarded that bond modification.
Ms. Giddings?
Yes, Your Honor. This incident did take place at the MARTA station, and though the charge was amended because there was no physical contact, the defendant did threaten to shoot the employee in the head because he was upset and not getting this $5 refund he felt that he was entitled to for the Breeze card. If I may inquire, my GCIC indicated that this was his first charge. Ms. Harris, do you see anything else other than this new burglary? Because I was under the impression.
No, that's it. That's correct. This is
Okay.
his,
So
burglary
this
is his second arrest.
burglary is his second arrest. Okay. That being the case, Your Honor, well, we would ask that instead of a signature bond, that you just make the $3,000 a surety bond. He's got bigger fish to fry in Superior Court.
Okay. I normally set my bonds, especially if they're signature bonds, generally not only based on the charge, but based on if he violates it, what he'll have to pay. Given that the charge has been reduced, I'm going to reduce the amount, the $3,000 to a $1,000 good bond with all the other conditions, Ms. Helen. Okay.
Understood, Judge.
All right. So if you will get that to me, I'll get that signed. And do you need those conditions, or do you have the previous bond?
I have the conditions, Judge.
Okay, very good. Good luck to you, Mr. Woods. Who do we have next?
We have position number 34, Mr. 48.
This is also going to be an arraignment and a bond hearing.
Yes.
Is that right?
Come on, 48.
That's correct, Judge.
All right. Good morning, Mr. Portier. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? You have to speak up for me, sir.
Yes, sir.
All right, thank you. Mr. Portier, you've been charged in case, can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Mr. Portier, you've been charged in case 22 CR 0078003G with terroristic threats and acts and simple battery family violence. Each of these charges carries a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen?
I do, Judge.
How do you plead, Mr. Portier? Guilty or not guilty?
Thank you.
We'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. I set these bonds in November, on November 15th, a $2,000 good bond for the terroristic threats and $3,000 good bond for the simple battery. Has anything changed, Ms. Helen?
Yes, when I went and spoke to Mr. Portier, what's changed is that Judge, he understands the seriousness of this case. However, if he's still taking it to a jury trial, he cannot make the $2,000 surety bond since it was set, Judge. And so we are asking for a bond modification to no more than $1,000 surety bond for Mr. Portier. And just to go into the factors, Judge, he's 25 years old. He does have a son who lives in Fulton County. He's 6 years old. His mom does live in Fulton County, so she's been here for a long time, giving him strong family support in Fulton County. His dad currently lives in the Bahamas, but he does have the support of his dad and his family. He has a brother in Fulton County. He's also a lifetime resident. So I don't believe he's gonna abscond or leave or go somewhere else, Judge. And so I do understand the allegations in the case. He has had no contact with the alleged accuser. And so he understands the seriousness, Judge, but we are asking for that reduction specifically because Mr. Portier cannot afford the $2,000 surety and has not been able to post it since it was set. And we are also asking that, again, he be given an opportunity to enter our community. He's looking to get his GED. He doesn't want to reoffend or have any other charges added, Judge. So we are asking for that bond modification to no more than $1,000 surety.
Ms. Giddings?
Yes, Your Honor, we're asking that the bond stay the same as you have previously said. The allegations are that Mr. Portier threatened to punch his mother in the face, and he actually took a fighting stance as if he were going to strike her, and his brother had to intervene to protect his mom. And as a result of that, Mr. Portier became a little upset. And as he left the room where he and his mom and his brother were, he pushed past her and either elbowed her or intentionally bumped her with his shoulder as he was leaving the room. He does have a history. He was arrested for simple battery, family violence, 2 counts in 2015. He has a burglary from 2014. And violations of probation in 2017. And his most recent charge was a burglary, theft, and theft by taking in 2018. So we feel that the bonds as set are appropriate.
Anything further, Ms. Helen?
Yes, Judge, and I do hear the simple battery from 2015. I don't know if that involves the same person in this case, Judge. But again, we are asking for that $1,000 surety bond for both charges.
It does not involve the same person, Your Honor.
Okay. I'm gonna modify the terroristic threats to a $500 good bond. I'm gonna modify the simple battery to a $1,500 good bond. So there'll be a total of a $2,000 good bond with the same condition, Ms. Helen.
Good, Judge.
All right, good luck to you, Mr. Portier. Who do we have next?
Position 16 and 17. Mr. Harden.
Okay.
I'm gonna look.
And this is going to be a negotiated plea, is that right?
talking to the.
Okay, I'll put you down for.
Who's representing Mr. Harden?
Okay.
What's up?
Which position is that, Judge?
16 and 17. This is Mr. McLean's case, I believe.
That is correct, Judge. He's currently on the phone right now. We can move to
We're gonna,
another-
we're gonna have to take Mr. Harden in a moment. His counsel is on the phone.
Understood, Judge.
Judge, we're gonna move on to position 39, Mr. White.
Okay. So this is gonna be a non-negotiated
Judge.
plea? Yes.
I'm sorry. I'm on the 7th floor and there's a lot going on up here. If we can just go ahead and get him done.
Mr. McLean, okay. Mr.
Just
McLean.
got off the phone now, Judge.
We have
Okay, all right, thank you.
new announcement. Toy Clark is a negotiated plea.
Okay, so Mr. McLean, we're on position 16 and 17, Mr. Harden.
Okay.
That's
Your
a
Honor,
that's a negotiated plea, correct?
he really says he wants to do a negotiated plea. I think, let's try to do that. He sounded a little shaky, but, I said, be sure. If you're sure in the morning, we'll go ahead with the plea. And I think, if he's sure today, let's do that.
Mr. Harden, can you hear me?
Yes, John.
I'm Judge Eric Morrow. This is the state on purpose calendar. Do you agree to have your case heard by video today?
Yes.
Okay, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Mr. Harden. Ms. Campbell? You're on mute.
Yes, Your Honor. The offer on position 16 is 12 months to serve 45 days, credit for time served 40 days, balance to be probated, as well as stay away from 150 Bell Street Southeast. The offer on position 17 is 12 months to serve 40 days, credit for time served 40 days, the balance to be suspended, and he needs to stay away from the MARTA station.
Court reason is the balance probated for position 16.
You said what reason is it probated?
Yes.
Your Honor, his history. Let me go into his history.
So you just want him to report to probation without any conditions?
Yes.
Okay.
I do believe he should be on probation in at least one of the matters based on his history. He has a pending entering auto in Superior Court. He has a 21 conviction for second-degree burglary and criminal damage to property. So that's the state's position.
Okay, Mr. McLean?
And of course, that's the same issue we discussed in our meeting, and he understands the difference between probation and balance suspended. I told him, gee, it might be a typo. You might get, might be lucky tomorrow, but nonetheless, as a probated case, he asked the court to accept his negotiated plea. I'm hoping that maybe 12 full months of probation wouldn't be necessary. Maybe just checking on him for 3 or 4. But that's just my thought, Your Honor. He's asking the court to accept his negotiated plea of guilty.
All right, Mr. Harden, it's my understanding that in case 21 CR 007909Y, you wish to plead guilty to loitering and prowling and theft by taking, and in position 22 CR 006330Y, you wish to plead guilty to criminal trespass. Is that correct?
Oh, as to why I wish to plead guilty? No, he asked me, are you? I was pleading. I didn't want to, but due to the fact I've been here and after everything that I've been through, I don't feel like I should. I want to be out of here. I mean, I really want to be out here, y'all, but due to the fact of all what's been taking place with me, I feel like those charges.
Okay, Mr. Harden, does he have anything else? Hold on, does he have anything else holding him?
The entering auto.
Okay, so Mr. Harden, you still have a charge, and that's entering an auto. That's a felony. So you
those charges. Your Honor, those charges was.
You're not. It's my understanding that even if you plead guilty to these charges today, that you're still going to be held in on those other charges.
Those charges that y'all are coming to me with, I had already taken care of those charges prior. I've never had the charges that they're charging me with. I took care of those charges months ago. I mean, it's like this double jeopardy because I had no charges prior at Fulton County period. With no
Okay, Mr. Harden, I don't have any control over that. You're going to have to speak to counsel regarding those other charges. But it's my understanding that you do have other charges that are holding you in. If you okay, Mr. McLean.
Yes.
Given what he has said, I do not feel comfortable taking this plea today.
Understood.
I mean, see, this is what I'm not understanding. I had charges.
Okay. So, Mr. McLean, I want to put him back on the calendar for next week. Mr. McLean?
Yes.
And if you'll explain to him that, he's saying that he's not guilty. So I'm not going to accept a plea from someone who tells me that they're not guilty.
So get out of jail, right?
Okay, so what would you like for me to do with, I can either put it on the calendar for next week for you to talk to him, or it'll just be jail jury. Which would you prefer?
I think jail jury would be the better of the two.
Okay, all right, thank you. Who do we have next?
Next, position 39, Mr. White.
And this is a non-negotiated plea also?
Correct, Judge.
All right, good morning, Mr. White. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Sir, yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir. Let's see. The no further contact, is that the only issue as to why it's non-negotiated?
Also the Family Violence Intervention Program, Judge.
All right, what's his history? Ms. Harrison?
He has 30 cycles. Last arrest was a probation violation in 2022. Underlying charge was not indicated. He has a 2015 possession of Schedule I controlled substance out of Douglasville. A 2015 given false name, drugs not in original container, also out of Douglas. A 2016 DUI, also out of Douglas County. 3 violations of probation. And his last arrest, he has a 2010 burglary conviction. That's in Haralson County. That was a felony conviction. Other arrests are outside the 10-year period.
Thank you, Ms. Harrison. Ms. Giddings?
Yes, Your Honor. In addition to that, he had an obstruction of a law enforcement officer and a person hindering a 911 phone call in 2013. He has 2 burglaries in 2003. I do realize that it's quite remote, but it is still a burglary nonetheless. And he had 2 arrests without convictions for 2 counts of simple battery in 2011 and an arrest without conviction of a battery in 2014. The allegations in this incident is that while on patrol, Officer Santo of the Atlanta Police Department heard a woman scream, "Let me go." And she went to investigate to see what was happening. And when she pulled her cruiser around the corner and flashed her emergency equipment to try to get Mr. White's attention focused on her and away from his wife, she saw him trying to pull her from a vehicle. And once Mr. White was taken into custody, he tried to remove an item from his front pocket, and not knowing what that was made Officer Santa a little bit nervous. So she pulled and drew her sidearm, and then it was found that it was less than an ounce of marijuana that Mr. White did not want the police to find. Given his history and the allegations, the simple battery bond that he has, as well as the possession of marijuana bond, we thought were appropriate, as well as the recommendation of time served on the marijuana and 12 months to serve 14 days, credit for time served 7 days, to take the family violence intervention program, and to have no further contact with his wife. If Your Honor is not leery about him returning home and she wishes to have him back in the home, then we would have no issues with no further violent contact. However, we think that the family violence intervention program needs to be in place, because whatever was going on between he and his wife, he needs to understand that he cannot manhandle her if she does not wish to comply with his requests.
Have you spoken with the victim, your office, Ms. Giddings?
Yes, that's why it was no further contact, because at the C calendar, that is what she requested at the time.
Okay. Ms. Helen?
Yes, Judge. And again, this is a non-negotiated plea with the contact being at issue. And I just want to make it clear that the state does agree to no further violent contact. Because I've spoken to Mr. White. Miss Redden and him are currently have a child together. They're currently living together. So that's why we were asking for the no further violent contact. And so when I spoke to Mr. White, the FDIP is $600 to $700. It's a class for 24 weeks. He's not able to afford that whatsoever. Has lost employment and income due to being incarcerated. And I just want to bring this up that it wasn't a new charge. It was FTAs. And so when I went and spoke to him for those FTAs, because this case is from 2018, the first one he never received. He's been living with his mother and also sharing that address. And Ms. Redden also lives in that group too. That the original address that they did have when it was just Mr. White and his mom, 1883 Francis Ave, Atlanta, Georgia, 30318. And then the next FTA, they had actually moved. So, Judge, we are asking for that FVIP to be removed. Mr. White states he's not able to afford to complete that 6-month program class.
So you're asking this court to put him back into the household and not require him to do any type of course to help with his problems. Is that what you're asking this court?
Judge, no, Mr. White is willing to do any type of substitution, community service, anger management, any type of recommendation. It's just the 24 weeks, and at that cost, he would not be able to afford that and complete that. But no, Judge, we are not stating put him back into the household with nothing, but he is willing to do community service, anger management.
Position was already neutral.
Okay.
If I may be heard, Your Honor.
Yes, I just want to, I'm just being made aware that the possession of marijuana has already been null pros, and that's been signed, and that was done in 2020.
Okay.
Okay. So just so you know, Ms. Giddens, I'm not going to put him back in the home and not have him do the FVIP. So
Okay.
if he is going, if you were going to address that, then I'm going to require him to do the FVIP and have no further violent contact if that's what he wants to accept. Was that what you were going to address, Ms. Giddens?
Yes, Your Honor.
Okay, thank you. So that's what I'm going to do, Ms. Helen. So if he wants to accept that, then
Judge, yes, he does accept the offer as apparently at this point negotiated, Judge, with the FVIP. No further violent contact, but we just asked one thing of pretrial services. He believes he has a current hold. DeKalb County, can we get at least if it's a misdemeanor or felony for DeKalb County? What kind of hold that is?
I did not see that.
okay. Well,
I see a DeKalb County hold on Odyssey.
It is, but it doesn't indicate what type of level charge it is.
Or pretrial services,
it looks
Trespassing in the cab.
I'm sorry, you broke up a little bit.
Trespassing? Did you hear me?
possession, is that what you said?
No, trespass.
There you go.
Trespass.
Thank you.
Trespass. Oh, okay, thank you.
Criminal
Thank you.
trespass.
Thank you, pretrial services. But yes, Judge, he does agree, and this is a negotiated plea at this point.
Your Honor, the state would have no objection if the court wishes to waive the probation fees for a year in order to give Mr. White funds available to take that class, because it is going to cost about $800.
Okay, thank you. Mr. White, it's my understanding that in case 19 CR 0019998F, you wish to plead guilty to simple battery family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Absolutely.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you've given up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Mr. White, I'm going to waive the fees for you while you're on probation to help you get and stay on your feet, but you're going to have to be on probation for the entire time, okay?
Yes, sir. Thank you so
All
much.
right. You're welcome. Good luck to you, Mr. White.
Thank you, Judge.
Love you, mama.
Position 38, where?
Okay.
I have an update, Judge. It's not a negotiated plea. It's non-negotiated, but the only aspect that Mr. Ware just wants to ask this class for is that the death class is about $50, I believe, or $50 or $60, ranging from there. He's just asking for a substitution of community service equal to the one death class. But other than that, he agrees to the plea. No contact, stay away.
Is this your case, Ms. Giddings?
Yes, Your Honor, it is.
Do you have any objection to 20 hours of community service?
No, Your Honor.
Okay. So instead of a deaf class, it'll be 20 hours of community service. Is that okay, Ms. Helen?
And it is okay, Judge, and we want to say thank you. We also want to ask for those probation fees to be waived for the year. Mr. Ware is residentially challenged. He does not have income whatsoever, and he would really need that waiver.
Okay, I'll waive the fees.
Thank
All
you,
right,
Judge.
anything further before I take the plea?
No, Judge.
Ms. Giddings?
Yes, Your Honor, we're asking for 12 months to serve 30 days, credit for time served, 23 days, balance probated, 20 hours of community service, stay away from the incident location, and have no further contact with the victim. This actually took place at 3155 Roswell Road, Northeast Atlanta. The name of the business is Hancock and Harrell, common spelling. And Mr. Ware was seen by one of the owners of the business leaving out of an office suite carrying a battery-powered pressure washer I can't speak, excuse me, battery powered pressure washer under his hoodie type jacket. And when he was asked to stop, he dropped the pressure washer and tried to run. The owner then wrestled him down to the ground and held him until police arrived. Does the defense stipulate to jurisdiction, venue, and identity, as well as a factual basis?
Yes, we do stipulate to the factual basis, venue, and ID, and we would like this court to accept the plea as negotiated.
Nothing further from the state, Your Honor.
Thank you. Mr. Ware, it's my understanding that in case 22 CR 0078048, you wish to plead guilty to theft by taking, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Ware. I'm going to waive the fees for you while you're on probation to help you get and stay on your feet. And is there any objection to the probation terminating when he completes the probation?
No, Your Honor. Once he completes the 20 hours, yes,
Okay,
it may terminate.
And
We understand, Judge.
the probation will terminate when he completes the community service. Good luck to you, Mr. Ware.
Thank you, Judge.
Next.
Position 21, Hill. Come on, Mr. Hill. That's Ms. McLeod's case, or there she goes.
Okay, and what are we gonna do, Ms. McLeod?
Your Honor, this is going to be a non-negotiated plea.
Okay. Good morning, Mr. Hill. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
You want to, Judge, yes.
Yes, thank you. Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, thank you. You can put your hand down, Mr. Hill. May I have the history, please, Ms. Harrison?
$18 cycles, last arrest, July of this year for failure to appear. Underlying charge was not indicated. Records reflect an open case pending for possession of firearm by convicted felon, simple battery, criminal trespass under case 20 CP 194863. Record also indicates an additional open case that is currently in dormant bench warrant status, 20 CR 004948F, simple assault, family violence, criminal trespass, damage to property. That's in Judge Richardson's courtroom. Record also indicates an open probation in 2016 for aggravated assault with a deadly weapon, possession of knife or firearm during the commission of a felony, terroristic threats and acts, simple battery against police officer. Case 16 SC 143405, it was first offenders, not indicated if it's sealed. A 2016 theft by conversion felony, nothing further to add.
Okay, Ms. Campbell.
Yes, Your Honor. The state's recommendation is going to be 12 months served, 365 days, credit for time served, 22 days. And that sentence is to run concurrent on both counts, which is there's a criminal trespass and a loitering and prowling. As pretrial mentioned, the history is it's lengthy in the state's opinion. It's also concerning in the state's opinion because as pretrial mentioned, he's on several probations already. And so while he's out on probation, he's committing additional offenses. And some of the things that pretrial didn't know is that there have been several other arrests for criminal trespass within the past 4 years. I had that he was arrested in 2018. So in addition to the convictions that pretrial mentioned, I have that he was arrested in 2018 for criminal trespass. He was arrested in 2019 for criminal trespass and criminal damage to property. And his entire history consists of these types of violations. This is a co-defendant to another person on the calendar, Christopher Jackson, and I believe a third co-defendant that Your Honor already addressed earlier. The state's concern is the facts in combination with the history. And those facts are that on the date of November 14th of this year, officers actually got a call for a burglary in progress. So when they arrived at the property, 3326 Delmar Lane, they learned that the neighbor to that property had called 911 because she saw about 4 people enter into this home. The home was under renovation, and as soon as the officer parked his patrol vehicle, he did see a male exit the home, and the male had on white gloves. As soon as he saw that male exit the home with the white gloves, he attempted to speak to the male, but the male ran back inside the location. At that time, the officer went to the rear of the location to try to locate said male, and there was nobody there. At that time, the officer did try to gain entry to this home, but they learned that all the doors were locked. Not only were the doors locked, but when they knocked, nobody answered. Additionally, they did see movement inside the home. So at that time, they did get over their loudspeaker and they did announce for all the occupants of this home to come out of the home. Nobody came out the house. At that time, another officer had to get a search warrant for the location because nobody was listening to the officer commands to come out the home. Nobody was answering the door and the doors were locked. From there, the homeowner did, the officers were able to contact the homeowner. And when they spoke to the homeowner let them know that nobody was supposed to be in the house at all. That the last time somebody was allowed on the property was a week ago. And so at that time, they actually ran the tag number or the registration information for the box truck that was parked in front of the location. And the person who answered the phone was actually the father of this defendant, Mr. Mitchell Hill. And the father had received a call from this defendant. And the defendant told his father to come pick the truck up because he was getting ready to get in trouble. So from there, the father was able to convince the defendant to come out of the home. And so when this defendant came out, he actually came out with 5 other people. So there was a total of 6 people that exited the home, and none of them were supposed to be in the home. And I mean, they were essentially robbing the home. It was 6 of them. They had a box truck, they had gloves, and they didn't listen to any of the officers' commands to come out. The state is concerned because, like I said, with the prior history with these types of incidents, criminal trespass, theft by conversion, theft by taking, the state is concerned that if he's allowed to be back into the community so quickly, he will continue to commit these types of crimes because he continues to do them repeatedly. So that is the reason for the state's offer. The state does believe that he needs to be sat down for some time to appreciate the seriousness of his conduct, that it's illegal and it's not okay to do things like this within our community. We have had contact with the victim. He did say that the property had internal damage to the structures and to the doors. So the property was damaged within, at the time. So that is also a concern to the state. At this time, we have asked the owner to provide pictures and receipts for the damage that he had to repair, but we haven't received it yet. So the state's offer is the 12 months to serve the 365 days. And that's the state's recommendation.
Okay. Your Honor, it's my understanding, I'll be with you in just a moment, Ms. McLeod. I just want to make sure that I'm clear from the state's point of view. It's my understanding Mr. Hill does have an aggravated assault and a simple battery that was a conviction, first offender. Does he have any other convictions? You're muted, Ms. Campbell.
Yes, Your Honor, course brief indulgence. There is also, I believe there's at least 2 convictions for criminal trespass. One from 2019. And then he's got an open case in Cobb, I believe.
Yeah,
That's the most recent arrest, but as
I
far
want
as the
I want
conviction,
convictions, please.
okay, Your Honor, course brief indulgence.
Okay. Thank you.
Seek reset. Let's seek reset.
Ms. Harrison, can you help?
I'm checking, Judge, but it was all I stated is all I'm showing.
So 2 convictions, 1 for criminal trespass and 1 that he took first offender on?
I'm looking now as well, and I apologize. I wrote down all of the arrests, and typically I bold the convictions, but on this one I didn't. He has a theft by conversion conviction from 2017, and that was a felony. So he got a non-negotiated guilty plea on February of 2017 for theft by conversion, as well as theft by taking. I also have that he has, and I do apologize because Odyssey's going slow. As pretrial mentioned, I had that he has the first offender conviction or probation for felony terroristic threats, as well as ag assault with a deadly weapon, as well as obstruction from 2016. So that's 2 so far. I believe there are additional. I'm just.
Okay, if you find anything additional, just let me know. Ms. McLeod?
Yes, Your Honor, my client is 32 years old. He tells me that he works, he does DoorDash, and he is also the primary caretaker for his 84-year-old grandmother, suffers from dementia. Your Honor, my client was not the only one who apparently were at this location on the day in question. I believe I heard the prosecutor say there were 5 people, a total of 5 people came out of the house. 2 of those people have been offered pleas, which were time served, Your Honor. They were all arrested at the same time. I do not believe that my client's history is such that he could not receive those same terms, Your Honor. And I would ask the court to consider giving him the same terms as he enters his plea today, Your Honor. I do not believe the prosecution has said anything which would negate what I'm asking for, because the other co-defendants also had records. Nothing further, Your Honor.
Anything further, Ms. Campbell?
Not at this time, Your Honor.
The only additional arrest or conviction, Judge, is a hit and run in 2016.
Okay, thank you, Ms. Harrison. Mr. Hill, it's my understanding that in case 22 CR 007808E, you wish to plead guilty to criminal trespass and loitering and prowling. Is that correct?
Yes, I'll take the conviction, please.
So you wish to plead guilty, is that my understanding?
Yes, if that reduce the bond or use my signature, yes, I would take that.
Okay, I'm not understanding. Mr. Hill, the only thing I'm asking you is whether you are pleading guilty to criminal trespass and loitering or prowling. It's a yes or no answer to me.
Yes.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, I am.
You understand that you have a right to a trial by jury on these cases, and that by pleading guilty, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'm going to accept the plea, your plea, Mr. Hill. Given that it's a criminal trespass and an loitering and prowling charge, and what I have given to previous defendants with similar histories, it's going to be 12 months to serve, 44 days, credit for time served, 22 days, balance suspended, stay away from 3326 Delmar Lane.
Thank you, sir. Thank you so
Good
much.
luck to you, Mr. Hill.
Thank
Who do
you.
we have next?
36, Terry S.
This is a negotiated plea.
That's correct, Judge.
Good morning, Mr. Theriot. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You've been charged in case 22 CR 007940B with criminal trespass and possession and use of drug-related objects, which I believe is being null crossed. Let's see, can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, thank you. You can put your hand down. Ms. Giddings?
Yes, Your Honor. We're asking for time served and to stay away from the incident location of 235 Peachtree Street Southwest, Atlanta, 30303. Mr. Theriot was found sitting on a wall at the MARTA station, and when he was approached by MARTA police, he pulled a pill bottle and a 6-inch tree stick from his pocket. In search incident to arrest, a glass pipe was found in one of his jacket pockets. Defendant is in violation of a criminal trespass warning and MARTA suspension and may resume riding MARTA on January 19th of 2023. Nothing further.
Ms. Helen?
Yes, Judge, that is our understanding of the plea. We do accept that plea. We do stipulate to the factual basis, venue, and ID.
Mr. Theriot, it's my understanding that in case 22 CR 007940B, you wish to plead guilty to criminal trespass. Is that correct?
That's good.
Are you under the influence of any drugs or alcohol this morning?
No, no, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury? You don't want a jury trial, do you?
No, sir.
So you understand that you're giving up your right to a trial by jury by pleading guilty?
Can you explain what that means?
No.
You're still on mute, Ms. Helen, if you're talking to me. Oh, okay.
Thank you. I apologize. I apologize, Your Honor. I just wanted to clarify to Mr.
No, you're fine, Ms. Helen. So he the question was, he understands that he has a right to a trial by jury, and that by pleading guilty, he's given up his right to a trial by jury. Do you understand that, Mr. Perry?
Yes, sir, do.
Okay, has anybody forced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated. Mr. Theriot, good luck to you, sir.
Thank you, Judge.
Also, Judge, we do have the Spanish interpreter case in here, Mr. Herrera. If we can do the breakout here, and then also for Mr. Dennis Murphy, we have Mr. Jackson Christopher.
Okay, so,
He can call in the courtroom at 404-612-2392.
Mr. Murphy has requested a reset until Thursday on that matter, given some technical issues that he's having. So we're gonna reset Mr. Jackson until Thursday, 12/8.
Okay, and then what about the Spanish interpreter case?
Can we do the breakout room with you all right now?
Yes, that'd be perfect. And then Judge, I have a quick announcement.
Okay.
For position number 6, he refused to come to court.
All right, so we'll reset position 6. Whose case is that? That's Ms. Helen's case?
That's Mr. McLean's, but I believe he's 5 and 6. Is it 5 and 6 the same person?
Oh, okay. 5 and 6. So you want to reset him till Thursday or till next week? Mr. McLean.
Yes, sir. Let me grab my calendar. All right.
I apologize, Mr. McLean was just working here for 1 second.
Here we go.
It's time served, so perhaps Thursday would be best, Your Honor.
Right.
Thank you, Mr. McLean.
He was equally adamant yesterday. He said he didn't want to come to court.
So what would you like to do with him?
Let's reset it 1 week and I'll go talk to him again and explain that it would be good to make sure that he had the arraignment and had the full rights of a defendant, and he still insists on not coming to court, then all we can do is waive the presence, waive the arraignment, and go to jail jury.
Okay, so we'll reset him 1 week, and if he won't come out next week, you can file a waiver.
Sure.
5 and 6. Okay, any other announcements, courtroom 2, before we go to the breakout?
Yes, also for position 1, I was told that we don't need him. Mr. Bartley.
Bartley's not available because he's a weekender. He only comes to jail on weekends.
Okay, so are you gonna file a waiver?
We don't know him.
Well, if he's not being held on this case, shall we just reset it back to the division judge?
Yes.
Okay, jail jury?
No, it's not jail jury because the reason he was thought to be in jail was he's under a 1-year sentence. But when you really look at the detail of the felony 1-year sentence, he does it on weekends only.
Okay, so we'll return him to the division judge.
Yeah, reset further notice, division judge.
Okay. Okay, so can we go to the breakout room now? Is there anything?
Yes, Judge, we're good for the breakout now, while you go to South Annex.
Mr. Murphy, I made that announcement for you about Mr. Jackson. Did you have something else?
Yeah, Judge, you reset Tuesday the 13th, and I'll go see.
Okay, so you want to reset till next week?
Yes, because he has another hold on, so I want to meet him at the jail. And talk to him about it.
Okay, so Mr. Jackson is being reset until next week's calendar. Position 22. Okay, so let's put Madam Interpreter into a breakout room with courtroom 2.
Yes, thank you, Judge.
I'm sorry, is that Attorney Murphy leaving the courtroom?
Yes.
Was he leaving for good? Because I wanted to address just one matter before he left.
Okay, Mr. Walker has something he would like to address.
Just to revisit position 1 on the add-on, I understand that he's going to be submitting an order to have the defendant rebooked under the correct name, but I want to inquire why the judge is on the line. Once Your Honor signs that order, who should we direct that order to at the jail to make sure that happens? Because obviously all this needs to be
That's not my
less than
position
48
here.
hours.
That's not my position here. That's not my defendant.
I'm sorry, who had position, Mr. Baldy?
Yeah, it was Mr. McLean.
I'm sorry, Mr. Murphy. I'm sorry.
It's all good in.
Okay, have a good
Well,
one.
I'm sorry, but if Mr. McLean's on the line, where do we, once we get it signed, where does the order need to be sent to at the jail? Because I understand that we're under a time constraint.
Booking. And jail records.
Can the jail confirm that? Are they on the line?
That's where I sent mine. I sent one to
Okay.
booking and I sent one to jail records.
Okay. Mr. McLean, okay. I just want to make sure we're all on the same page because I don't want us to come back on Thursday and be in the same situation.
Thank you, Mr. Walker.
Make sure everybody send their non-process to me, please, to Commissioner Lewis at this time if you can.
All right. So let's go to the South Annex. Are we ready at the South Annex? Well, I don't know if we can do anything. Well, that was because now all the attorneys are in the breakout room.
Good afternoon, Your Honor.
Good afternoon. I don't know if, let's see.
She's position 27. She's a conflict. Her attorney with Ms. McLeod.
Okay, well, good. Ms. McLeod, are you with us? Ms. McLeod?
Good afternoon, Your Honor. I'm here.
Okay, so I believe this is Ms. Malloy, is that right?
Yes, Your Honor.
Can you hear me, Ms. Malloy?
Yes, sir.
Okay, good afternoon. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Ms. McLeod, what are we gonna do with Ms. Malloy today?
She will be taking plea today, Your Honor.
Okay, very good.
It's a negotiated plea.
Ms. Campbell?
Yes, the state's offer was 12 months to serve 70 days, credit for time served 35 days. No further contact with the victim in this matter, who is her daughter. The initials are, it's a minor. The initials are TR, as well as the FVIB program, and a stay away from the incident location, which is 2145 O'Hara Place Southwest.
Okay, Ms. McLeod.
Yes, Your Honor, those are the terms as we understand them, Your Honor. My client was a little bit concerned about this stay away from her daughter because this is a minor, 17 years old, Your Honor. But of course, if the court ultimately says that she has to stay away from her child, she's prepared to do that. Also concerning the FVIP, Your Honor, my client is currently not working. She doesn't have any money to pay for that course. My understanding is it costs around $800. So I would ask if the court, well, would waive the fees for it, if that is possible, because she really doesn't have any money.
I can waive the probation fees. There's nothing I can do about the actual course, Ms. McLeod. But I'm happy to waive the probation fees for her to help her get and stay on her feet. How old is her daughter?
17.
Where's her daughter now?
I believe her daughter is living with
My daughter, I'm
daughter's
sorry.
mom.
She's 15.
And Your Honor, if this is non-negotiated or negotiated, I wanted to clear that up, because if it's non-negotiated, I did want to put some facts on the record concerning the relationship between the parties. It is her it is her biological daughter, but it's my understanding that the aunt has custody of her biological daughter. This defendant does not have custody of her child, according to, I'm sorry, the grandmother has custody of the minor child.
That's not true.
Well, that's what we spoke to the victim and we spoke to the aunt, and that's what we were told. So if it's going to be a non-negotiated, I would like to put the state's contacts with the victim and the victim's family on the record, because it might be a dispute as to what the daughter is asking for, what the victim in this matter is asking for. We're told that she wants no contact whatsoever with her mother. And
Okay,
this is
and
an ongoing issue.
does that come from the victim advocate speaking with her?
Yes, Your Honor. We've had contact with her 2 different times about this case.
Okay, so if you've spoken with her and that's what her wishes are, then I am going to grant her wishes in that regard. So.
I understand, Your Honor. I was under the impression that those were not the daughter's wishes, but
Okay, well, that's going to, so it's gonna be the FEIP, it's gonna be the no further contact. But I will waive the fees, so that makes it negotiated, correct?
yes, Your Honor.
Okay, anything further, Ms. Campbell?
No, Your Honor. Sorry, no, I was on mute. No.
Okay, you're fine. Let's see, Ms. Malloy, it's my understanding that in case 22 CR 007528H, you wish to plead guilty to battery family violence, is that correct?
Yes,
Are you under the influence of any drugs or alcohol this morning?
no,
You've been represented by counsel. Are you satisfied with your counsel's representation?
yes,
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
yes,
Has anybody forced or coerced you to plead guilty?
no.
Okay, I'll accept the plea as negotiated, Ms. Malloy. I'm going to waive the probation fees for you while you're on probation to help you get and stay on your feet, but you're going to have to be on probation for the entire time, okay?
Yes, sir.
All right, good luck to you, Ms. Malloy.
Thank you, Your Honor.
Thank you, Your Honor.
I did ask for a stay away. Just to clarify, I did ask for a stay away as well. I don't know if Your Honor added that.
What is the location, Ms. Campbell?
The location is 2145 O'Hara Place, Southwest.
Okay, we will add that to the order. Anything further, Ms. McLeod?
Yes, Your Honor, that concludes my business before the court today. May I be excused?
Yes, am I going to see you this afternoon?
I don't know, Your Honor. I'm relaxed.
Ms. McLeod, I thought I was gonna give you a call for this afternoon.
Okay.
Okay?
Yes.
All right.
All right.
Thank you, Your Honor.
See you then.
Could I have Mr. Walker call again for that jail courtroom extension 22392?
I'm calling right now, Mr. McLean.
I gotta talk to him.
Okay, so can we go to someone else?
I was trying to go to position number 20, but I guess we can go someplace else.
Okay, who do we have at the South Annex?
This is position number 7 and 8.
Who represents? Is this Miss Helen's case? Is Miss Helen in court? Room 2?
Two people, a male and a female.
Miss Helen, this is Miss Clark, position 7 and 8.
That'll be Mr. McLean's case. Out of the females, I have Miss Britt, who's the add-on, position 2.
Okay, do you have Miss Britt there, South Annex?
Sure, give me a moment.
Should be.
Yeah, because Miss Malloy was on the add-on.
Yeah. Should be Tanaya Britt should be over there.
Yeah.
You say Tanaya Britt?
Yeah.
Tanaya Britt.
Oh, Tanaya.
Add on 2.
She was in E10, E10, E10.
That's correct.
Thank you.
That's correct.
Okay, no problem.
And Miss, I take it that Miss Helen, you don't have any other cases in courtroom 2?
I do not.
Okay, so the rest are Mr. McLean's? Okay. All right, so I guess until he comes back, that we don't have anyone we can take. All right, we'll be in recess until Mr. McLean comes back.
That
All right. I think the court's off the bench for a sec.
Are we bringing the Spanish interpreter up?
We're just gonna announce that we're gonna reset that case. And we're gonna announce a reset for Toy Park as well, which we thought was gonna be negotiated, but right now it's not.
I'll do that in a moment. So, Mr. McLean, what position is this again?
Mr. Herrera is number 20. Your Honor, because we have a courtroom full of people, there's no confidentiality here, so we were able to make some progress in that I conveyed to him the definition of what he's charged with. I also discussed with him in a one-way fashion so that he was not giving me information in front of other people. I told him several other things one way. What we propose to do, Your Honor, is reset this case a week, and the interpreter and I will figure out a telephone way to do a confidential interview and then have an announcement for the court. He has a hold anyway, so there won't be any harm.
Okay, so we're resetting this till next week, 12/13.
Yes, Your Honor.
Okay. Do you need for Madam Interpreter to say anything more to your client before I release her?
No, I explained all that to him in advance.
Okay. All right, thank you. Madam Interpreter, we appreciate your time this
You're
morning.
very welcome. I'll be waiting for your call, Mr. McLean. Have a good day. Bye-bye.
And we've got the email. So,
Thank
Your
you.
Honor, I was mistaken on Toy Park. I thought it was a negotiated plea. I was mistaken. That needs to be reset as well.
So that's position 7 and 8, Ms. Clark.
Right, and that's because it's not a time served offer. So I need to explain that to her further and several other things.
So for next Tuesday, 12/13.
Yes, Your Honor.
Okay, so South Annex, are you still with us? Okay, when they come back on, I'll let them know. All right, where can we go in courtroom 2?
Is there anything else in courtroom 2? Did we ever do? Maybe I'm mistaken. Did we ever do Mr. Brant Clark, number 4? Was that ever addressed?
I just said that was Joe Jury. I thought we did his arraignment.
Okay, then I forgot to write it down. So I'm good. Thank you.
We also have position number 12, hold for announcement.
I have that. Hey, Judge, I have that announcement for position 12.
Okay,
I believe that's Tabitha Fink. She refused the attorney visit. I was gonna reset it, but I wanted to give her an opportunity. She has a time served deal. So if South Annex was able to bring Ms. Fink, or she actually came to court, I'd like to talk to her about that.
South Annex, are you still with us? So we're done in courtroom 2, is that right?
That's correct, Judge.
Okay, so we're waiting for the South Annex to come back online. We do have also 2 DV bench warrants cases to take up.
That's true, Judge, and I believe we have an add-on calendar.
Right, and we have Ms. Britt in South Annex, I believe, and I guess position 3, Robbie Mosley is in the South Annex. as well.
No, he's here in at the jail, Judge. They're gonna bring him.
Oh, they're bringing him? Okay.
We also have one more of the co-defendants from that home that was under construction with the 7 people, 6 people, position number 35, Ronaldo Stevens.
Yes, he was released.
He was released. Okay, thank you.
Okay, so while we're waiting on the South Annex, let's do the DV bench warrant cases. Mr. Brian Watson and Ms. Carr, I believe, I see them on the line. Who's representing Ms. Carr? Courtroom 2, you mute if, can you?
There we go.
Mr. McLean,
Ms. Carr's case is mine, Your Honor.
okay, are you ready to proceed on that?
Yes.
Okay, good afternoon, Ms. Carr. We appreciate your patience with the court. We're going long for the 9 o'clock calendar. I know that you are on the 11 o'clock calendar, so we appreciate you waiting for the court. Go ahead, Mr. McLean.
I looked in Odyssey, Your Honor, the address to which the two return to sender envelopes are imaged as documents in Odyssey went to the correct address. There's no reason in the world why those should have been returned to sender. It's the correct address, correct spelling of her name. So I don't know why the post office didn't leave the envelopes there.
Because the apartment number was not on there.
Is there an apartment number, Mr. McLean?
Yes,
Ms.
sir.
Carr?
Is that it? There's an apartment number? Okay, well, that explains the entire thing.
What's the apartment number, Ms. Carr?
1107.
1107.
Very
Yes.
good. All right.
And of course, the state would like to be heard, Your Honor.
Of course, Mr. Walker.
So this is a 2019 case. We are almost in 2023. Ms. Carr missed 2 court dates. I understand that her address was not correct or didn't have the apartment number. But at the end of the day, it's the defendant's responsibility to make sure that the clerk has an updated address. She was released on a citation. And it's the state's position that at this point, because she's had a FTA in 2020, a FTA in 2021, Judge Roth did issue a bench warrant with no bond. The state's recommendation is going to be a $1,500 pretrial services bond with the condition of no contact with the victim, Ms. Imaine Young. So the state is requesting that she's remanded into custody and then released through pretrial services. And hopefully this case will not go another 3 or 4 years.
All right, well, we have verified that that an apartment number was not on there. I'm going to give you one additional opportunity. Ms. Carr, if you miss court, we're going to add the apartment number. If you miss court again, then the bench warrant will not be set aside, but this time it will be set aside, given that we found an error. All right, so you have to make sure that if you move or that you check in with the court to make sure that you don't miss another hearing. Otherwise, it won't be set aside the next time. So you understand, ma'am?
Yes, sir.
Okay, all right. Mr. McLean, if you'll prepare that for the court, and you're free to go, Ms. Carr. Mr. Watson, good day again also.
Am I going to get another court date in the mail to this address?
And it will, yes, and it will include the apartment number. So that appears to be what the problem was, that your apartment number was not on the notice that was sent out. We're making sure that we've clarified that with the clerk, and you'll be receiving the next notification of a court date, hopefully to that apartment number. Okay?
Okay, thank you.
You're welcome. Have a good day, ma'am. Who's representing Mr. Watson?
You too.
I will, Your Honor, Mr. Watson.
Okay, and what's going on with Mr. Watson? Good morning. Oh, good afternoon again, Mr. Watson.
Your Honor, he was incarcerated several years in Virginia, and he states that as soon as he got out of custody in Virginia, he notified the authorities here that he was out, and he apparently missed a court date in the meantime.
So we saw Mr. Watson, was it last week? Right? No, am I mistaken?
I don't think he was last week. No.
Okay, so what you're telling me, Mr. McLean, is that Mr. Watson missed court because he was in custody.
Right, in another state. And he described to me, it was interesting, I'll be very brief. He described to me a letter he wrote, and I said that doesn't rise to the level of a detainer letter because he only sent it to one party and not both simultaneously. So the detainer didn't work. And as soon as he got out, he said, wins court.
Okay. Ms. Campbell?
Yes, Your Honor. It looks like he FTA'd back in 2016. I'm not sure if Mr. McLean is saying that was he incarcerated in 2016 or?
Right, were you in the?
That's when he FTA'd.
Right, the 2016 date, Mr. Watson.
Yes, sir.
Okay, were you in the regional jail awaiting the state prison, or were you in the state prison by that time?
In the regional jail.
Okay, but you were on your way to the state prison at that time, and you have proof
Yes,
of
sir.
incarceration. You can
Yes,
provide incarceration, and Virginia can provide that as well, correct?
Yes, and I gave the proofs of incarceration to when I applied for the new court date. I submitted that paperwork also.
Okay, clerk has it. Our clerk has it.
Yes, correct.
Thank you.
Ms. Campbell?
Well, provided he has the proof that he was incarcerated during the court date that he FTA, the state would have no objection to the bench warrant being lifted, but the proof does have to be provided. So I would defer to the court on that.
Okay, so let's make sure that we do have it. I know that he says that he's already provided it, but let's get him to provide it again, just to make sure that the court has it. And I want to make sure that I have his correct address. So Mr. Watson, can you put your correct address in the chat for the court so that we can make sure that we have the right address on file?
No problem, sir.
Okay.
And
May I have?
somebody say
sorry,
that to me because I don't get to see chat here.
Okay, good. So what do you need, Mr. Watson?
I just wanted to add that this was a joint case, and the other person, when they went to court, there was no process, it was dismissed. So I was just wondering, is there anything that I can do today or something to, expedite the case?
Does he qualify? Do you know if he qualifies for your services beyond today?
We haven't talked about finances yet, Your Honor, but
Okay.
I'll be glad to talk with him further and see if he qualifies. Oh, and I misspoke. I do have the ability to display chat here. I thought I did not.
Okay, so
And I have my proof of incarceration right here with me too, also.
okay, so if you can, where can he email that to, Ms. Lewis?
You can email it to me. That's fine.
Okay, so if you email that to Ms. Lewis, she'll send you her email address and email it to her, and we will prepare, if you'll prepare the set aside, Mr. McLean.
Okay.
And we'll get Mr. Watson's address in the chat, and that should take care of it. Okay, anything further on Mr. Watson?
Now, I'm about to take the picture and email her now. Is there anything else that I have to do, or do I still have the bench warrant?
No, that's going to be set aside. Make sure that you have Mr. McLean's contact information so that you can see if you qualify for his services going forward. If you do qualify for his services going forward, then he can help you with the remainder of what you were speaking of earlier regarding this charge, okay?
And that will be handled today? Or
No,
at another court date?
it won't be handled today. It'll be handled in the future.
Okay, thank you. I appreciate it.
Okay.
No, it takes 24.
Mr. Watson, do you still have my phone number from our contacts yesterday?
I do, but let me confirm. Could you just give it to me again?
Yes, 770-891-4755.
Okay, thank you. I appreciate it. And I'm about to send the documents over now.
Okay, thank you. All right, who do we have in the South Annex?
Ms. Clark, position 7 and 8.
Right, I need to reset Ms. Clark's case because it's not time served it's not time served, so let's reset it 1 week, Ms. Clark, and I'll come to the jail and see you.
So it'll be time served if I.
No, I can't promise that. We're talking with the state, we're negotiating, but we will talk further. And I will come to the South Annex to see you.
Shit, I thought we talked about this.
All right, so we'll see you next week. We'll see you next week, Ms. Clark.
Right, next week.
What are they saying? I'm lost.
Ms. Clark,
I'm
Mr.
lost. What are you saying? This is a misdemeanor. What is?
Okay, hold on, Ms. Clark.
I will come visit you at the jail this afternoon. It'll be late this afternoon, but it will be today. and we'll discuss this further. Probably about 5 o'clock.
I'm ready to get out of here.
Would you,
Hey. Oh. Oh.
Not happy. Not happy.
okay, who do we have next?
Position number 12.
Is that Frank?
Yes, this is Ms. Frank, is that right?
That's Miss Helen's case. Miss Helen? Where's Miss Helen? Okay. What you got? What you got? All of a sudden, Miss Frank shows up on thing. So I guess it's Helen asked him to come in.
Where's Ms. Helen?
It's position number 12, Your Honor.
We're trying to get her attorney on the line. I think she has the rest of them. I signed them.
There you go.
I apologize, Judge. Which position are we?
Okay, we're with position number 12, Ms. Frank. Ms. Helen, what are we gonna do with her this afternoon?
Yeah, can I speak to Ms. Frank? Ms. Frank, I tried to come out and see you and they stated you refused the attorney visit. Would you like to speak with me about your case today?
South Annex, you're on mute. South Annex. We need for somebody from the South Annex to help us.
Oh, what did it?
You're on mute, Officer Milton. All right, can you hear me, Ms. Frank?
Yes, I can hear you.
All right.
Can you tell me what I'm charged with?
Ms. Frank, you've been charged in case 22 CR 007941Y with criminal trespass.
Okay, I'm sorry. Can you repeat that again?
Criminal trespass.
You say criminal trespass?
Yes, ma'am.
Okay, and where am I criminal trespass?
Wait, hold on, Ms. Frank. Ms. Frank, I give you that information. Would you like to speak with me about your case? The judge can't give you information about those things or legal advice. Would you like to
Excuse
speak?
me?
Would you like to speak with the public defender's office about your case?
And you are?
A public defender with Fulton County. My name is Catrice Helen.
I'm sorry. Go ahead, Judge.
So if Ms. Frank does not want to move forward with the public defender's office, we are going to consider her pro se, Judge.
I think that Ms. Frank is having some other issues, Ms. Helen. What I would like for you to do is I'm going to reset her until Thursday. I would like for you to see if you can speak with her between now and Thursday to help her understand. But I think there's some other issues and we may have to have a social worker go by.
That's exactly what I was going to do today, Judge, and I'm going to request that social worker try today or tomorrow.
Okay, very good. Ms. Frank, I'm going to reset your case until Thursday. I'll see you back here on Thursday.
But I'm still not even getting no information.
Okay, well, you'll get information from Ms. Helen. Officer Milton, can we please have the next person?
I think that was it, Your Honor. Have a seat for me, please. Please have a.
Your Honor, wait, is Ms. Helen still there? Can we revisit number 12? I just reviewed her criminal history. There is none. I agree, there probably are some MH issues, but due to there being no history, she was refusing to leave a gas station, probably due to those concerns that we have. I'm just willing to not process it. I think that
Mr. Walker.
Okay.
going down that road.
Bring Ms. Frank back up then.
I don't know if you still want a social worker to go by maybe for a placement or where she can go, but
Sure, I will definitely get a social worker
I
out.
think that was the issue.
Miss Frank, just listen to me, ma'am.
Yes,
Your case is gonna be dismissed, okay?
okay,
All right, so, so the state is dismissing the case against you, and we're going to have a social worker come by to speak with you, okay?
okay.
All right, very good. You have a good rest of your day, ma'am.
I'm still not understanding.
Thank you, Judge.
If I understand, who else do we have, Officer Milton?
As soon as Officer Golfin comes back, cause she took the other lady back because she was, having a little situation. I don't know if you saw her before.
So you let me know what, we still have cases on the calendar to get through, so
Okay.
is she bringing her back or what?
She took her back because she was I think I'm not sure she did her, if you all did her already.
We need Miss Britt, position number 2 on the add-on calendar. Is that who was taken back?
Hold on,
Okay.
hold on, Your Honor, let me find out. I need you to have it.
And what about, are they still looking for Robbie Mosley, position 3 on the add-on calendar?
And PD Helen, on that offer, you put, or on your announcement, you put non-negotiated plea, but it was a time served offer, so.
That was actually a clerical error.
Okay,
And I was going to announce that as soon as Mr. Mosley was here.
okay.
And I do believe the jailers are working together.
Okay.
All right, so I don't want to waste this time while they're looking for these people, because this courtroom is going to have traffic court in 30 minutes, so we're on a time crunch.
Your Honor, he's running to go get him. It's gonna take about 10 minutes.
Okay,
That most likely.
okay. So let's go through the calendar, Ms. Lewis, so we can get that out.
And Your Honor, briefly, I'm sorry, I do have an announcement on position 26. We already addressed it, but I just wanted to provide a point of clarification, just briefly. Mr. Keon Kendrick,
Okay,
that was the one that you reset until next Thursday, I believe, in order for the state to accuse his criminal trespass case that is holding him on a $500 bond. So I did get the bind paperwork and I will have it accused by next Thursday. But I did want to provide a point of clarification for the record. I know that previously the defense attorney stated that he had served 100 days on this case, or 100 or something odd days on this case. And I did, we did reach out to the College Park Police Department and we did verify that he's actually only served 1 day on this case. He was arrested and released the same day. So he hasn't served any time on the case that was before the court today, which is the theft by shoplifting and the willful obstructions. I just wanted to put that out there. I know you're going to make your decision next week, but I just wanted the court to know he hadn't served 100 days on this case.
Judge, we just were stating to the court what his booking number recorded on Odyssey, as in he's been there 109 days. So I stated that he was arrested for the 1 day for the criminal trespass, but it's just what Odyssey shows as his most recent booking and how much time he spent there.
okay.
Thank you, Judge. And just one clarification, I tried to get it reset to next Tuesday, not next Thursday.
Yes, it is set for me next Tuesday.
Okay, thank you.
Yeah, we'll have it accused by then, but I just wanted to clarify he served no time on this case, but I didn't know if there was confusion because that's what I heard, but I want to make sure.
I think the confusion that Ms. Helen's talking about is that you said Thursday and it's next Tuesday as opposed.
Okay, thank you.
All right, so Ms.
Your
Lewis.
Honor,
Yes,
add on to Ms. Britt, she refused.
okay. We'll reset her for Thursday, 12/8, okay?
That's it, Your Honor?
Yes, that's it. Am I
Okay,
gonna see you,
thank you.
am I gonna see you this afternoon?
No,
No, all right. See you
bye.
next time. All right, Officer Milton.
Okay.
What was the last one on Mosby, position number 3 on the add-on?
12-8, she refusal. She's reset to 12-8.
I got that for 2, but for
Oh.
3.
Oh,
They're still waiting for 3 to come out, I believe.
great.
We still waiting on 3?
I
Yes.
think it should be about 10 minutes.
Okay. All right, well, let me go over the add-on calendar first. This number 1 is set to SAP for Thursday, the 8th. Remember, there may be an add-on calendar for these cases. I don't think the calendar been produced already with that. Position number 2 on the add-on is reset also for Thursday, December the 8th, and we're holding for position number 3. On the regular calendar, position number 1 is set for the notice. Turn back to the original judge assignment. Position number 2 was a plea. Position number 3, defendant was arraigned, case was set for trial. Further notice, the bond was modified. Position number 4 was arraigned, case was set for trial. Further notice. Position number 5 and 6 is set for SAP next Tuesday, December 13th. Position 7 and 8, same announcement, except for SAP 12/13. Position number 9, same announcement, except for SAP 12/13. Position 10 was a plea. Position number 11 was a plea. Position number 12 was non-cross. Position number 13 was a plea. Position number 14 was a non-cross. Position number 15, defendant was arraigned in case set for trial for the notice. Position 16 set for SAP 12/13. Position 17, same announcement, except for SAP 12/13. Position number 18, except for trial for the notice. Same announcement for 19, except for the notice. Position number 20, except for next Tuesday, December 13, SAP. Position 21 was a non-negotiated plea. Position number 22, except for SAP next Tuesday, 12/13. Position 23, defendant was arraigned in case set for trial for the notice, same announcement in 24. Position 25, defendant was released, case set for the notice, returned back to the original judge assignment. Position number 26 is set for SAP Tuesday, December 13. Position 27 is a plea. Position 28, defendant was arraigned in case set for trial for the notice. Position 29, defendant took a plea. Position 30 is a non-cross. Position 31 was a plea. Position 32, defendant was arraigned in case set for trial for the notice. Bond was modified to a $3,000 SOB through the jail. Position number 33 was a plea. Position 34, defendant was arraigned in case set for trial for the notice. The bond was modified to a $2,000 good bond. Position 35, defendant was released, case was set for the notice. Position 36 was a plea. Position 37 was a plea. Position 38 was a plea. 39 was a plea also. Position number 40, defendant was arraigned in case was set for trial for the notice. Bond was modified to a $1,000 good bond. Position 41 was a plea. Any questions? Please make sure you give me your non-process and your orders in a timely manner. I have to get the judge to sign off on the paperwork.
All right, so we have Mr. Mosley with us.
I'm gonna come down to the courthouse and sign and, fill out the bond modification and blasting game. You announced 1617 as a reset, but I think our final decision on that was really Dale Jury.
Yeah, it was Joe.
So you're gonna waive the arraignment, file a waiver arraignment? Okay, 7-0, that's fine. Thank you for the correction.
All right, are we ready for Mr. Mosley?
Yes, Judge, we are.
Okay, so good afternoon, Mr. Mosley. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can put your hand down, Mr. Mosley. What are we doing with Mr. Mosley this afternoon?
The judge did say negotiated plea is for a time served, balance suspended offer. Mr. Mosley does accept it. As I'm sitting here next to him, really his big fish is the other hold he has. And he's asked me if I can ask this court if there's any way they could help him get on a felony calendar. And this court does not put any cases on felony calendars and has no influence over that.
Okay, who's handling this?
This is my case, Your Honor, and the state's recommendation is 12 months to serve, 365 days, credit for time served, 232 days. Technically, there is no balance because it's a 12 months to serve, and with the 2-for-1, he has served more than a sufficient time to complete the sentence.
Ms. Helen?
Yes, Judge, that is our understanding of the plea. We do accept that on behalf of Mr. Mosley, and we do stipulate to the factual basis, venue, and ID.
Okay, Mr. Mosley, it's my understanding that in case 21 CR 0077776A, you wish to plead guilty to battery against a female who is pregnant. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this afternoon?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Is that a yes?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Mosley. Good luck to you, sir.
Thank you, Judge.
All right. Any other questions or concerns?
No, Judge.
Okay, if not, I'll see y'all next time.
Thank you.
Okay, everyone.
I'm sending my null process, Ms. Lewis. Bye.
She'll get on to you.
Have a good afternoon.